Dear members, dear Commissioner-designate, dear all, I would like to welcome you, both those present in the room and those watching us live on web stream, to the confirmation hearing of Mr. Michael McGrath, the Commissioner-designate for Democracy, Justice and the Rule of Law. This meeting is held jointly with my colleagues from the Internal Market and Consumer Protection Committee and the Legal Affairs Committee, whom I will pass the floor shortly for their introductory remarks. Having received your replies to our written questions, Commissioner, we take note of your readiness to cooperate with the European Parliament, to be regularly present in our meetings and plenaries, to follow up on Parliament's legislative initiatives and share timely information with us as co-legislator and arm of the budgetary authority. We obviously count on you to inform our committees in advance of all upcoming proposals and to provide us with detailed justifications when urgent action is required. This will ensure transparency and allow Parliament to properly exercise its prerogatives. The Commission should indeed be an honest broker in all legislative procedures and interinstitutional negotiations, ensuring equal treatment of Parliament and the Council. This is very important in the context of a revision of the framework agreement between the European Parliament and the Commission, and we count on you to fulfil these commitments. Mr. McGrath, if confirmed, you will be entrusted with a portfolio which includes topics falling in the remit of the committee I represent, such as democracy, the rule of law and the protection of fundamental rights, media freedom, and strengthening the fight against corruption. Therefore, we are ready to hear your plans on how the rule of law can be effectively upheld within our Union and the protection of fundamental rights and our democracies reinforced. You will also have in your remit aspects linked to criminal justice and data protection, and we are here to hear more about your commitments in those areas. But your mission goes further, and I will now pass the floor to my colleague representing the IMCO committee, Anna Cavazzini, for her opening remarks. Anna, the floor is yours.
Yeah, thank you, Javier. And also in the name of the IMCO committee, I welcome you, Commissioner-designate, dear colleagues, but all the guests also watching online to this hearing. You know that consumer protection is at the heart of IMCO's portfolio and also yours. Consumer protection affects the everyday life of citizens in the European Union. It's very close to the EU citizens. It's contributing to make the single market work effectively. So I want to really underline the importance of this hearing to look forward. We look forward to commitments, to clear commitments, how to protect consumers and how to empower consumers in the digital and green transitions. We regret, of course, that consumer protection is not part of your title. Nevertheless, we trust that it will constitute a significant pillar of your work. I would like to inform all of you that before the hearing, Mr. McGrath replied in writing to a questionnaire. The written answers have been distributed to all members in all languages. And in line with the guidelines for approval of the Commission, this is Annex 7 to the Rules of Procedure, during the evaluation of the hearing, coordinators have to state clearly whether they consider the candidate to be qualified both to be a member of the college and to carry out the particular duties he has been assigned to. I would like to also inform you that the confirmation hearing will be streamed live on the Parliament's internet site, and it will also be possible to access the video recording of the hearing on the same site a couple of hours after the hearing. Interpretation is provided in all 24 languages, and as usual, we ask all the speakers to speak clearly and slowly, and you can, of course, also use your own language. Now, I would like to pass the floor to my colleague, the chair of the Jury Committee.
Thank you, dear Anna. First, the overall structure of the confirmation hearing. The Commissioner-designate will be given a maximum of 15 minutes for a presentation, and then we will proceed with 3 rounds of questions. So the first round of questions by political groups coordinators, then the second round of questions based on the overall distribution of speaking time among the political groups. This will include a representative from the non-attached members, and the round will be concluded by questions by the chairs of the invited committees, and we have many of them today. And lastly, we go to the final round of questions by political groups in reserve order. The Commissioner-designate will have 5 minutes at the end of the meeting for a closing statement. I want to recall that the Committee on Legal Affairs assessed the question of a potential or actual conflict of interest and has raised no objection to the holding of this hearing. Commissioner-designate, this confirmation hearing will also cover the remit of Committee on Legal Affairs, which is very important for the EU citizens, and it touches on their daily lives. This will include areas that have not necessarily been fully fleshed out in your mission letter, but they do fall fully with the justice portfolio, such as cross-border cooperation in the area of civil justice, civil law, company law, commercial law, contractual law, procedural law, family law, and ethical aspects of the virtual worlds or the future of justice as explored in the recent Draghi report. Today we bring jointly our 3 committees to this confirmation hearing, as we often cooperate with each other when it comes to all the elements of your portfolio. With these opening remarks and structured confirmation of the hearing with the rules of procedures, I hand back the floor to the Libe Chair, please.
Thank you, Chair. And now I give the floor to the Commissioner-designate, Mr. Michael McGrath, for his presentation of no longer than 15 minutes. Mr. McGrath, the floor is yours.
Thank you and good morning, everyone. Chair Zarzalejos, Chair Cavazzini, Chair Kuciuk, can I just start by expressing my own deepest condolences to you, Javier, and to all of our Spanish colleagues, and indeed to the Spanish nation on the terrible loss that you have suffered in recent days in Valencia. Our hearts are broken, and my thoughts and prayers are with all of you. Honourable members of the European Parliament, I am pleased to appear before you today as Commissioner-designate for Democracy, Justice and the Rule of Law. It's more un privilège et le vin chaud.
It is a huge privilege for me to be here with you today in the Parliament to discuss very important issues for the people of Europe, and I would like to thank you for giving me this opportunity.
Merci tous ceux qui ont participé.
I'd like to thank all of those who've been involved in organising this hearing. It's an important exercise for our democracy.
Together, you represent no fewer than 8 parliamentary committees. This underlines the broad nature of the portfolio President von der Leyen has entrusted me with. Upholding the rule of law, protecting the fundamental rights set out in the Charter, ensuring free and fair elections, a vibrant pluralist media and enhancing consumer protection are topics that touch the very core of what the European Union and this Parliament represent. I want to begin, therefore, with a promise to work closely with this House, consulting and listening to your advice at every stage of my work, should you confirm me as a European Commissioner. Like you, I am a parliamentarian. I have served as a public representative for 25 years, first at local level, then as a member of my national parliament for over 17 years, most recently as Ireland's Minister for Finance. I have the deepest respect for you as the directly elected representatives of the citizens of the European Union. One of the politicians who inspired me during my formative years was John Hume, a peacemaker, a statesman and a proud member of this Parliament for 25 years. I assure you that in my work, your voice and the voice of the people you represent will be heard. Honourable members, in asking for your support today, I will set out my vision for this portfolio over the next 5 years and how it fits into the President's broader political guidelines on European security, competitiveness and the green and digital transition. In the current geopolitical context, we must cherish and defend the values that make the EU a beacon of peace, tolerance and hope, including democracy, respect for fundamental rights and the rule of law. Many risks were identified prior to this year's European elections, including disinformation threats and sophisticated manipulative methods using AI. The fact that there were no major disruptions to the conduct of the elections was remarkable. but it did not happen by chance, and I want to pay tribute to the work of Parliament and Vice President Jourova in particular. As President von der Leyen has said, our democracy is a constant work in progress, and over the next 5 years, should you confirm me, I will make this a priority. Central to our approach will be the Democracy Shield, a new integrated framework to bring together all the key elements needed to protect and defend our democracies from foreign information manipulation and interference. And as the directly elected representatives of European citizens, your input is essential. I intend to take into account the recommendations from the work of the special committees on foreign interference, and I want you to have joint ownership of this work. First, working closely with my colleagues, we will need to improve our expertise, preparedness and capacity in countering foreign information manipulation, interference and disinformation, while guaranteeing a reliable information framework. Second, we must strengthen resilience in our societies, improving awareness of disinformation and media literacy, particularly among younger generations. Media freedom and the safety of journalists are central to a questioning, dynamic and democratic society. Third, we must ensure integrity of electoral processes and the safety of election candidates. In the face of mounting threats to their security, we need to protect election candidates from undue pressure, particularly women, who are often subjected to abuse amplified by misogynist stereotypes. And we will champion civic engagement and participation, including through youth dialogues and citizens' panels, to bring citizens' ideas directly into our policy making. European democracy needs to be more vibrant. The sense of belonging to a society that values and respects who you are, that protects your individual rights, is the basis of our union. Should you confirm me, I will work tirelessly to uphold the Charter of Fundamental Rights. This will include building greater awareness of the Charter among citizens and empowering civil society. The importance of upholding fundamental rights must mean that compliance with the Charter should be factored in to Member States' access to the many benefits which flow from EU membership. Where breaches of the Charter occur in the application of EU law, we stand ready to act, using all means at our disposal, including launching infringement proceedings, which have proved to be an effective tool. And by demonstrating our steadfast commitment to protecting fundamental rights, we will also ensure all candidate countries are proud of the union they seek to join. In today's world, where the resilience of our democracies, societies and economies are constantly put to the test, our values are what bind us together and make us stronger. Just as citizens need to feel democracy working for them and that their fundamental rights are protected, they must see that the rule of law is upheld across the European Union. And they look towards the European Union to make sure that this is the case in all Member States. Honourable Members, if confirmed, the promotion and defence of the rule of law throughout our Union will be an absolute priority for me. I would like to acknowledge the unwavering commitment of Commissioner Reinders to defending the rule of law in our Union, and if confirmed, I intend to build on his work with your support. The rule of law is an essential safeguard for the functioning of our democracies, the protection of individual rights and the prosperity of our societies and economies. It lies at the heart of a union of equality, opportunity and social fairness. The Rule of Law report, developed by the Commission in the last 5 years, has proven to be an important tool to detect, prevent and address emerging challenges in Member States. I will fully engage with Member States, acting as an honest broker to prevent rule of law related issues occurring in the first place and to resolve those that arise as a forthright guardian of our values. I will also engage with civil society organisations and stakeholders on the ground. My emphasis will be on achieving measurable progress in addressing rule of law deficiencies. I believe we need to respond effectively to failings when they occur, and I will not hesitate to act where appropriate, using the full toolbox of measures at my disposal. Building on the existing Rule of Law report, I will oversee the introduction of a stronger focus on the single market. The rule of law is a precondition for mutual trust and a vital element of competitiveness and the fostering of a business environment that supports investment and innovation. I'm also committed to promote the rule of law in our neighbourhood, and I look forward to including more accession countries in the rule of law report as and when they are ready. Together with the Commissioner for the Budget, we will develop a closer link between the rule of law report recommendations and financial support. Respect for the rule of law is a must for EU funds. We will propose that EU funding also be dedicated to national measures, for example on fighting corruption and to protecting the EU financial interests. I will also propose the first ever comprehensive EU strategy against corruption to foster integrity, to strengthen coordination among all relevant authorities and stakeholders in this area. Honourable members, the world around us has become more fragmented and unstable. Organised crime groups are on the rise, targeting our society, economy and indeed our European budget. And this is why, if confirmed, I will work towards making the fight against crime more effective throughout the prosecution chain. I will work together with the Commissioner for the Budget to improve our anti-fraud architecture. This should include reflecting on areas in which the European Public Prosecutor's Office will need more powers to look at cross-border serious crime, in particular corruption that impacts union funds and cannot be handled alone by Member States. And I will work to improve cooperation between the EPO, Eurojust, Europol and OLAF. Every year, 75 million people in the EU fall victim to a crime, and many of you have expressed to me your concern as to how victims are treated. So I will propose a new victims' rights strategy to ensure a well-functioning, victim-centred justice system that not only aims to establish the truth, but also the right of victims to a remedy, and I will explore how we can strengthen the European arrest warrant. I will also propose a strategy on the use of digital technologies to ensure justice is more efficient, resilient and secure everywhere in the Union. If confirmed, I would like to explore how we can further strengthen our fight against crime. I would particularly value your perspective, and I look forward to the opportunity to engage with you on this important topic. Honourable members, at the border of our Union, there is a country courageously fighting to defend its freedom and the lives of its citizens. Since Russia's unjustified invasion of Ukraine, the EU has been steadfast in its support of Ukraine. I would like to pay tribute to the members of this Parliament for their ongoing support of Ukraine. If confirmed, I will continue to work to ensure that we play a full part in the efforts of the international community to ensure Russia's full accountability for the crime of aggression and the war crimes it is committing. Honourable members, the next Commission mandate will have a clear focus on enhancing European competitiveness. There are many ways I can contribute to this, in particular by promoting independent, efficient and effective justice systems which support a thriving investment and business climate. Simplified and harmonised rules in the area of civil and company law can substantially reduce administrative and legal costs associated with judicial proceedings for businesses. I think the time is right for a fresh look at the future of EU civil and company law, building on the conclusions of the Letta and Draghi reports. And I want members of this House, Member States, industry, SMEs and academia to be part of this reflection. In this context, we will examine how to promote the use of digitalisation to tap into the enormous growth potential of AI. This includes taking stock of work to date on finding the right balance for liability rules in this field to give citizens confidence that their rights can be effectively protected. And more generally, we will also need to look beyond company and civil law at the full range of rules applicable to business life. We will look together at how a new EU-wide legal status, the 28th regime, could help innovative companies grow by overcoming legal, administrative and fiscal barriers and creating common conditions for all key aspects of business activity. Honourable members, the single market has been the greatest single driver of the European economy. Further deepening of the single market has the potential to unlock considerable benefits for our consumers. And if confirmed, I will develop a new consumer agenda for the next 5 years. And this will address the digital and green transition, including sustainable growth and a specific action plan for consumers to be able to fully access goods and services in the single market. Product safety is an essential prerequisite of a thriving economy, and I am pleased that the General Product Safety Regulation begins to apply on the 13th of next month, and I thank all the MEPs for their work in advancing this important initiative. I recognise the concerns that many members have expressed to me regarding unsafe products sold through e-commerce platforms. In response and with your support, I will assess the need to update legislation and ensure enforcement. Our aim must be to ensure the compliance with safety requirements and consumer rights throughout the EU and a level playing field for all of the businesses in the Union. But for consumers to trust the market, they need to know that their rights are respected, also when they buy or navigate online. And that is why I will take forward a Digital Fairness Act to reinforce consumer protection in targeted areas to complement the existing EU digital rule book. I want to make sure that consumers are not exploited for commercial purposes, that social media influencers are not misleading our consumers, and that our children are sufficiently protected online. I will address dark patterns, marketing by social media influencers, addictive design of digital products, and unfair personalisation practices, and working with colleagues, the protection of minors from harmful content and practices will be a priority. I will ensure that the protection of our children from manipulative practices when playing online games remains a priority in consumer policy. Many members have raised the issue of digital subscriptions, noting that it is considerably more difficult to cancel than it is to subscribe, and I will work with you to address this issue. The General Data Protection Regulation has been a success, and I will ensure this legislation is properly enforced in a manner that is coherent across the Union and applied in line with the new EU Digital Rulebook. Dear honourable members, I do not underestimate the task at hand, nor the responsibility I am asking you to entrust me in upholding the most cherished values of this Union. I believe I have the qualities and experience needed to tackle the challenges ahead and to support President von der Leyen and my fellow Commissioner-designates in our collective work, not only in strengthening our security, safeguarding our values and boosting our competitiveness, but also proving our worth to European citizens and those who will join our Union in the future. In conclusion, I reiterate my appreciation for your engagement with me over recent weeks and the many policy suggestions you have put forward. I reaffirm my commitment to the Framework Agreement and the provision of complete and timely information to Parliament, honouring the principle of equal treatment of Parliament and Council. And should I be confirmed, I look forward to attending plenary debates and committee meetings on many occasions to engage in dialogue with you, cooperating in a spirit of mutual respect. We have much work to do in the years ahead, and working together, I know we can achieve a more prosperous and secure Europe and a brighter future for all our citizens. Thank you for your patience, and I look forward now to our discussion.
Thank you. Thank you, Mr. McGrath. Now we move to the first round of questions by the political group coordinators with 5 minutes slot each, within which there will be 1 minute for the question and 2 minutes for the answer from the candidate commissioner, with the possibility of a follow-up question from the same member, no longer than 1 minute, with 1 minute for the reply. Please stick to the time allocated, otherwise the development of the session will be very, very difficult. So we'll start with an EPP group, Mrs. Elena Dupont.
Thanks, Chair. And good morning to you, Mr. McGrath. Of course, very much welcomed what you had already outlined in your vision for the portfolio. But I'd like to pick up 2 words here that you actually said at the end of your intervention, which is a prosperous and a secure European Union, and allow me to address a question around that. First question stems also from a report you just also cited, the Draghi report, when it comes to the interlinkage between GDPR and AI and the complexity, and of course also the overlapping between those two, which might lead to our European companies falling behind AI advancement. They are confronted with regulatory uncertainty. They are facing disproportionate burden and a fragmented implementation of both, but especially of GDPR. That does not only undermine our very much values as European Union, but of course also undermines and hinders innovation, growth and competitiveness. So how would you like to address that, having also in mind that in the current trilogue it was just mentioned that we could probably overcome the GDPR and go for a reform of that? Thanks.
Mr. McGrath.
Thank you very much, Madam Dupont. And this is, I think, a very important question, and the upholding of GDPR, data protection, of course, is a fundamental right that we must stand over and defend as a union. But I do not believe that it is contradictory to our objective of improving the competitiveness of the European Union and indeed fostering and supporting innovation. And, of course, GDPR is technologically neutral, and its existence has not prevented, in fact has enabled the bringing forward of a whole range of legislative initiatives in the digital space in recent times, including the DSA, the DMA, of course the AI Act itself. And I think we can have both. We can have the highest standards of data protection within the European Union, while at the same time using all of the potential that technological advances provide to us to support innovation in our economy. And of course, the AI Act itself facilitates and strengthens the enforcement of the fundamental rights, including the Union data protection law. I think what is really important is clarity and consistency. I think those two issues are going to be really important over the period ahead. In that regard, I know that the European Data Protection Board has engaged in the application of Union data protection law in the area of AI, with the aim of coordinating the views of all the data protection authorities around the Union. So that issue of consistency, I think, is really important, that when companies seeking to develop and deploy AI in our Union, that they know how it will be regarded from a GDPR perspective throughout the European Union. And I know that at the end of this year, the European Data Protection Board will adopt an opinion binding on the data protection authorities regarding the processing of personal data for the development of AI models, and hopefully I'll have more time to respond to you in a moment.
A follow-up question?
Yes, the follow-up question would actually then be dedicated to a bit more of a security question. Your mission letter also tasks you to step up the fight against foreign interference and disinformation. Independent media is at the core of an informed society, and journalists do play a crucial role for any democratic society. How will you make sure that A, journalists are better protected, and B, independent media guarantees a fair access for each and everyone in order to take informed decisions? Thanks.
Mr. McGrath.
This goes to the heart of our union, and for me the implementation of the European Media Freedom Act in all respects is going to be a key priority. And as part of that, and in association with other initiatives that we have brought forward, the safety of journalists is going to be an integral part of our work. We have, of course, the 2021 recommendation on the safety of journalists, and we will continue to monitor Member States' actions in its implementation. And I stand ready to revise that recommendation to support effective application of the European Media Freedom Act safeguards for journalists. Of course, we also have the anti-SLAPP directive. Anti-SLAPP, which targets journalists. My ambition is to ensure that we have a swift and a strong implementation of the anti-SLAPP package, which of course includes both a directive on cross-border civil proceeding and a Commission recommendation applying to all types of proceedings. So that's going to be a very important instrument as well. We also need to look at aspects of jurisdiction and applicable law relevant to SLAPP cases.
Now, S&D, Mrs. Sippel.
Very much, dear Mr. McGrath. Democracy, rule of law and fundamental rights, as you mentioned, are the foundation of the European Union, and it's therefore very important to have strong and effective tools to make sure that member states are held accountable when backsliding on these foundations. So will you commit to expanding the rule of law conditionality regulation to cover all areas of rule of law and fundamental rights? And how do you envisage reinforcing Article 7 application? Can you confirm again that you will publish the Commission Rule of Law report on an annual basis? And how will you make sure that the recommendations are binding and more time-bound, potentially by making the recommendations linked to EU funding? And a final question on equality before the law, which is a very principle on rule of law. How will you ensure that principle, and what concrete actions are you planning to take in particular, given that minorities and women are disproportionately impacted by backlashes in rule of law?
Thank you, Madam Zippel. And my approach to rule of law will be, yes, to engage first and foremost, have dialogue with Member States, but please be reassured of my absolute determination to use all of the tools at our disposal, and then to work with you and to work with colleagues in the Commission and to work with Council on ways in which we can improve the toolbox that we have. When I stand back from the detail and I look at the progress over the last number of years in terms of the EU's approach to rule of law, much has been achieved, and due in no small part thanks to the work of Parliament and of course Commissioner Reinders. But we will take a fresh look at the tools. It is important that they are consistently applied. The rule of law report of course applies to all Member States and has recommendations for all Member States. I commit to being hands-on in supporting Member States when it comes to implementing the reforms in practice. I think we need to monitor and to track in a better way the implementation of the various recommendations that are made every year within the Rule of Law report, and we need to be prepared to use the tools at our disposal. The conditionality regulation is an effective tool. It is, of course, under the Commissioner for Budget, but we will be, in the context of the mission letter and the political guidelines commitment to strengthening the connection and the relationship between the rule of law recommendations and access to EU funds. We will, as a college and with the Parliament, be discussing all of the options that we have, particularly in the lead up to the next MFF. And in that regard, I think the lessons from the Next Generation EU, the Recovery and Resilience Facility, the Reform for Money principle, the deployment of super milestones has been a really important initiative in the context of rule of law, which has led to a lot of positive change.
Thank you. Your follow-up question, Ms. Sippel.
Yes, thank you. Mr. McGrath, you are also responsible for monitoring the application of fundamental rights, including protection of privacy and personal data, as well as, you mentioned, the enforcement of GDPR across member states. So what do you see the greatest challenges to these rights at the moment, and how you are concretely planning to safeguard them? You are also entrusted to promote data flows with international partners. How will you ensure that the adequacy fundings hold up in the European Court of Justice, as the previous ones, for example with the US, have been annulled by the court? And furthermore, how will you ensure that the new rules Commission is planning on data retention will also pass the test of the court? And maybe you can also come back to the question on equality before the law.
Thank you, Madam Zippel. So just to loop back for a moment, you asked for a commitment in relation to the Rule of Law report being on an annual basis. I'm happy to give that commitment and to working with you in relation to the reinforced application of Article 7, which of course is currently before the Council, and I think it would be a positive thing if the voice of Parliament, which of course initiated the current Article 7 that is before Council, if the Parliament was given an opportunity to present and have its voice heard. In relation to GDPR and data protection, I think the adoption of the procedural rules regulation is going to be an important initiative and will help to ensure the even-handed and consistent implementation of GDPR, particularly on a cross-border basis. So that for me is going to be a key requirement, and ensuring there's greater coordination through the work of the European Data Protection Board is something that I will also be aiming for. And again, just to reassure you of my commitment that in every respect there will be full equality before the law.
Thank you, Mr. McGrath. Now the floor goes to PFE. Monsieur Fabrice Leggeri, the floor is yours. 1 minute to question.
Merci, Monsieur le Président.
Thank you, Chairman. Mr. McGrath, the mission letter from President von der Leyen refers to the democracy shield and EU values. What about political Islamism and Islamic terrorism? Are they compatible with EU values? What will you do to help member states combat these scourges as they undermine our European values and attack our way of life and the EU common identity? What will you do to protect freedom of thought, freedom of speech, equality between women and men, when political Islamism is instrumentalizing EU institutions against us? Do you believe it is acceptable that the European Commission should be funding NGOs or universities linked to radical Islamic organizations, even linked to Hamas, which is a terrorist organization? On the 16th of October last, the director of the Turkish agency responsible for Erasmus Plus also referred to Hamas. What will you do to bring an end to such partnerships and the repayment of any EU funding given to such organizations in the past?
Thank you very much, Monsieur Leggeri. And from my point of view, respect for our values applies to everyone. Democracy, equality, rule of law, freedom, human rights, respect for human dignity. These are non-negotiable. And we have to ensure as a Commission and as a Union that we uphold our values in every respect and in all aspects of our work. And of course, the Charter of Fundamental Rights, which falls under my remit as a Commissioner-designate, has to be upheld. We will have the annual report in respect of the Charter of Fundamental Rights, which will now move to more of a monitoring report, and that is important. You speak about freedom of expression. That is a fundamental right and a very important building block of our democracy. But of course, it is not an absolute freedom, and there have to be an appropriate balance struck in ensuring that we do not in any way tolerate hateful language or anything that is moving into the criminal area that can have an impact on the citizens of the European Union. In relation to funding of NGOs and different groups, from my perspective, it is vital that we support organisations that respect and uphold our EU values. And that, for me, is the bottom line. And there are various checks and balances that are currently in place in the assessment of project applications and applications for funding by different bodies. As you know, we have some very successful programmes, the Citizens, Equality, Rights and Values Programme and the Justice Programme, which focus on EU values. And based on our past experience, the Commission will learn from the application of the values and the application of the checks and balances. But funding will continue to be provided to organisations and to programmes that support our EU values.
Thank you, Mr. McGrath. Your follow-up question, Monsieur Leggeri.
Monsieur le Président.
Thank you, Chairman. Mr. McGrath, in your written answers and your previous answers, you've insisted on the role of the Court of Justice of the European Union. My question is the following. As European Commissioner responsible for justice, will you encourage a government of judges against a government of co-legislators? In certain circumstances, decisions taken by the Court of Justice of the European Union run fundamentally against the will of states and the will of Parliament, to any extent against the sovereign will of people who have elected their representatives in a fully democratic fashion. In such cases, the only solution appears to be to give way to the Court of Justice. Or will you bring in some kind of new EU legislation that will allow us to counter decisions of judges which run counter to the sovereign will of the people of Europe?
Thank you, Monsieur. I think it is important that we all respect the primacy of EU law. Our EU values, which are in Article 2 of the Treaty, the Charter of Fundamental Rights, which will reach its 25th anniversary next year, again is EU law. I and fellow commissioners, if we are approved, will be guardians of the treaties. That will be our mandate. And of course, the overarching interpreter of EU law is the Court of Justice. But national courts are also EU courts. So the first port of call for the enforcement of EU law, for the interpretation of EU law, is the national court and the national judicial system. And then beyond that, of course, it will go to the Court of Justice if required. So we have, I think, a good system of checks and balances in place. But the fundamental point is we have to accept the primacy of EU law, and we have to accept the preeminent position of the Court of Justice as being the ultimate arbiter of EU law as it applies in all member states.
Let's move to ECR, Mr. Tobias Boczemski.
Thank you, Mr. Chair. Commissioner-designate McGrath. The European Parliament's Legal Affairs Committee has underscored the need to respect EU member states' legal sovereignty, particularly given the expanding scope, or what some call also inflation of EU law and its potential to encroach upon national competencies. Could you share your view on how national parliaments and courts should play a role in safeguarding member states' legal frameworks against possible overreach by EU institutions? Specifically, what steps will you take to ensure that national sovereignty is preserved and the EU legislation respects the principle of subsidiarity, remaining within the bounds of its intended powers?
Thank you very much, Mr. Bohinski. And I think this is an important question that we need to be clear about what the checks and balances are and the appropriate balance of power within the European Union. But I do think that on this question of subsidiarity, the treaties are clear on the matter concerned. The principles of subsidiarity and, of course, proportionality govern the very exercise of the EU competencies. And the treaties also provide for different instruments to ensure that these principles are respected. And there is, of course, a role for national parliament in ensuring that the principle of subsidiarity in respect of laws coming through the European system is being upheld. And I have seen that system work in practice in my own parliament. And I'm sure many of you in your own countries will have observed that as well. It's set out in Protocol number 2 to the treaties. And under the ex-ante early warning mechanism, national parliaments can issue reasoned opinions on draft legislative act. And of course, that is a tool that they have used. The preliminary reference mechanism, in addition, provides national courts with a procedure for dialogue with the Court of Justice of the European Union. And this allows for an ex post verification of the conformity of acts of the EU institutions with primary law, including the principles of subsidiarity and proportionality. So that procedure for dialogue, I think, is a very important mechanism and a channel that is there to be used to ensure that subsidiarity and proportionality are fully respected in all of the work that we do. But again, we have to respect the primacy of EU law over national law, and all decisions by the Court of Justice, including orders for interim measures, are binding on member states and indeed on national courts. This is a fundamental part of the EU's legal order, and it's the basis of everything else that we seek to do.
Thank you, Mr. McGrath. Mr. Boczemski, your follow-up question.
Thank you. My second question refers to the rule of law, because the rule of law mechanism, especially its link to EU funds, has been a point of contention, notably among Central and Eastern European countries. How will you ensure that this mechanism is applied impartially and transparently, preventing any risk of political misuse. We seek reassurance that all member states, regardless of their political orientations, will receive equal treatment under this mechanism. In short, how will you balance necessary EU oversight with a genuine respect for national legal sovereignty? Thank you.
Thank you for the follow-up question. I can give you that reassurance because I think it strikes at the heart of what we need to be about. We have to be impartial in the application of the full rule of law toolbox that we have. And, you know, I come to this with a fresh pair of eyes. I will make decisions based on the evidence and based on the facts that I see. I do not have any preconceptions. So I will engage in a very fair and even-handed manner with all member states. But nobody should be under any illusions. I will be prepared to act in a strong and forthright way to ensure that the rule of law is respected by every member state of the European Union. When it comes to the annual rule of law report, there is a well-established set of methodology. It is, of course, the Commission's view. It is the Commission's assessment, but they do take account of national authorities, civil society, international institutions. There are a whole range of people and bodies that input into the report, but ultimately it is the conclusion and the assessment of the Commission, and I will oversee this work very, very closely if I am confirmed, and I will be impartial in all of my work.
Now for Renew, the floor goes to Mrs. Zifrova Ostijanova.
Hello and welcome here with us, Commissioner-designate. I would like to touch on the media freedom side of the equation, so we can expand a little bit on that, because we know that for media organizations to fulfill their democratic purpose, they have to operate free from undue political influence. Journalists face threats, women in journalism face particular threats and unique challenges. So I want to ask and for you to expand on what are you thinking in light of the recent legislative developments in certain member states where political influence increasingly impacts or threatens to impact public broadcasting governments? How will you ensure that the European Media Freedom Act and anti-SLAPP legislation are effectively implemented? And how do you plan to navigate political pressures from member states while ensure effective implementation of the legislation? I was wondering if you could outline your ambition in this regard for the upcoming 5 years.
Thank you very much, Madam Zifrova Ostojanova. I can assure you will not bow to any pressure, first of all. I will examine everything on its own merits, but when it comes to protecting journalists, protecting independent media and supporting human rights defenders, there will be no compromise, because that is at the heart of what we stand for as a European Union, because their work represents an important pillar in the rule of law and in our democracy, and makes a very important contribution to the protection of our fundamental rights, and they exercise important watchdog functions, and they are in the community, they are in our member states, and they deserve our full respect and indeed our full support. So for me, working very closely, of course, with Executive Vice President Designate for Cunnan, the implementation of the European Media Freedom Act will be a top priority. And in that regard, setting up the new European Board for Media Services and its Secretariat will be an early priority that we must achieve. We will ensure the Commission carries out a regulatory fitness check of all Member States to make sure that the implementation of EMFA is fully on track. I also want to assure you that the consideration of pluralist media, the independence of media, will continue to be an important part of the annual Rule of Law report. It's one of the 4 key pillars of the Rule of Law report, and that will continue to be the case. So it will be complementary to the implementation of EMFA. And as I said, we stand ready to update the 2021 recommendation in relation to the safety of journalists, because we have seen, as we know to our cost, a number of murders of journalists within the European Union, and this is reprehensible. And we have to take a very firm stand when those who are holding others to account are punished as a result, because we all suffer if we allow that pattern to develop.
Thank you, Mr. McGrath. Your follow-up question?
Now it works. Okay. I'm going to slightly shift to a different topic that you touched upon in your opening words. It's the Victims' Rights Directive, because in response to the written questions, you mentioned that one of your core priorities is to leverage criminal law at the EU level to defend and protect EU citizens and its values. So regarding the Victims' Rights Directive, how do you intend to ensure that all key elements adopted in Parliament's positions are safeguarded throughout the interinstitutional negotiation process? And given that you listed this as one of your main priorities, how do you envision this progressing? Could you be more specific? Thank you.
I thank you for raising this, because it is a priority for me in the course of my work if I am approved by you, and I will need your support to get the Victims' Rights Directive over the line, because as you have touched on, the Council has adopted a different view in respect of a number of different strands of the Victims' Rights Directive. I believe we need to do more to support victims and to uphold their rights when it comes to access to justice, for example, when it comes to protecting the rights of victims. And my goal in the negotiations ahead will be to keep the highest standards originally proposed by the European Commission, which I know the report of the European Parliament on the revision of the Victims' Rights Directive is very supportive of the Commission's proposal. So I thank you for that. This is going to be a key priority. We now stand ready to start the institutional negotiations, and it's a file that I look forward working with you to getting stuck into.
Thank you, Mr. McGrath. Now the floor goes to Mrs. Strick, Greens.
Thank you, Chair. Dear Mr. McGrath, you seem to be quite positive about the progress being made on the rule of law, but I see actually an ongoing deterioration in a number of member states, despite measures being taken by the EU. So we need a more convincing enforcement strategy. So my questions, would you commit that every rule of law deficiency indicated in the rule of law report is accompanied by a specific recommendation, a deadline for rectification, and a tool to be used in case of non-compliance, including budgetary measures? And also ready to assess a possible link of a rule of law and fundamental rights deficiency with the EU budget in a transparent way. And in that sense, to trigger budgetary consequences in case of non-implementation of European Court's judgments. And are you ready to commit that you will assess compliance with milestones or with recommendations at the level of practice and implementation, and not only at the abstract level on paper, and to involve civil society in monitoring this compliance?
Mr. McGrath.
Thank you very much, Madam Strick. And to be clear, what I am positive about is the work of the Parliament, of the Commission and the Council in the progress that has been made in the toolbox. When I look back over the hearing Commissioner Reinders did 5 years ago, and I look at what we have now, the toolbox has been developed to a significant extent. We've more to do, and I'll come back to that, but the conditionality regulation didn't exist. The horizontally enabling condition on the Charter of Fundamental Rights didn't exist. The annual rule of law report didn't exist. So much has been done, but notwithstanding the improvement in the architecture, we are seeing slippage, and we are seeing backsliding, and we are seeing rule of law concerns, not just in one country or two countries, but when I met many of you privately, you shared your concerns with me about issues in your own country. So the rule of law applies to all member states, and that has to be the bedrock of our consideration of this issue. So while I acknowledge that progress has been made in the architecture and in the toolbox, where I think we need to do more and we must do more is in the follow-through, is in the implementation, is in the area of consequence. And that is where the mission letter, the political guidelines from the President, I think is very clear. Respect for EU law is a must for EU funds. And if we just use that as the foundation of our next step, then I think we will not go wrong. I will engage in a collegiate fashion with my colleagues in the Commission in respect of the next steps. I have looked at the different instruments that are there already, and I've formed my own opinion, but I have to be collegiate and work with colleagues in relation to where we need to go. I've already highlighted that the lesson from the RRF in terms of reform for money, super milestones, I think there are lessons can be learned from that. So for now we have the mission letter, we have the political commitment from the President, and I assure you I will work with you and colleagues to give effect and give expression to that commitment in tangible terms over this mandate.
Thank you, Mr. McGrath. Your follow-up question, Ms. Strick.
I agree with you, Mr. McGrath, that it's not about the tools, but it's about the use of the tools. And that should become more extensive and also with a stronger sense of urgency as our values are really under threat in a number of member states. So therefore, would you commit to make full use of the enforcement tools in cases of breaches of the fundamental rights of the EU, in particular infringement procedures based on Article 2 of the Treaty of the EU, of expedited infringement procedures, of applications for interim measures before the CGU, and systematic follow-up actions if these judgments are not being implemented? And on Hungary, would you commit to request an interim measure before the CGU in the case of the Hungarian protection of sovereignty law? And would you commit to support the Parliament's call for the Council to continue its formal Article 7 hearings in the case of Hungary and to address concrete recommendations as a follow-up? And would you commit to initiate the procedure under Article 7, paragraph 2?
Thank you, Ms. Strick. Ms. McGrath.
Thank you, Madam Strick. I'll start with the second part of your question first in relation to Article 7. I would like the Council to bring that to a conclusion in relation to Article 7.1 and to come to a view. I'm very conscious that the Parliament, I think it was 2018, initiated that particular procedure, and I think the Parliament's voice should be heard and should be given that opportunity to present before Council in that respect. And I will support the reinforced application of Article 7. We will examine the Commission communications around Article 7. Of course, the 2014 Rule of Law framework does provide for a formal dialogue with the Member States, and I think we do need to come to a view in relation to that. Yes, I am prepared to use the full suite of tools that we have when it comes to breaches of the Charter of Fundamental Rights. And my focus over the period ahead will be on building that closer link between the recommendations in the annual Rule of Law report and indeed access to EU funds. The Commission has not been shy in issuing infringement proceedings. I think in the justice area alone it's about 400 have been issued in the last 5 years. And on the issue of interim measures, we will ask the Court to deal with the case you referred to swiftly, and we'll keep under review all options that we have to bring about an outcome.
Thank you, Mr. McGrath. Now the floor goes to Mr. Arbanitis on the left.
Good morning, Mr. McGrath. Thank you for coming. I would like to tell you that you are taking over a portfolio that has a wide array of issues and is very popular in the agenda of the member states, meaning that in action we have problems, we have resistance from the member states, we have issues with the conditionality mechanism because often we have a problem with the reactions of the member states. So we have the toolbox, but we do not have the substantial political will. So that means that this conditionality mechanism means that it has less status, and it is obvious that we have a lack of political will. So what are you going to do about the framework of the rule of law mechanism, and what are you going to do so that it is applied in a uniform manner in all of the member states? Secondly, what are you going to do, which particular actions in order for this conditionality mechanism to function appropriately. Thank you.
Excuse me, Mr. McGrath. The floor is yours.
Thank you very much, Mr. Arvanitis, for your question. And I think the conditionality mechanism has proven to be an important tool. I'm conscious that it does come under the Commissioner for the budget, but of course its application is in respect of the principles of the rule of law, where there is an impact on the EU funds or the financial interests of the EU. So it is framed in a certain way, and as you know, it has been invoked. There is, in one particular case, in the case of Hungary, over €6 billion funds currently not available because of the Council decision in respect of the conditionality procedure on the recommendation of the Commission. And I want to acknowledge the work of all of the members of Parliament in the development of that mechanism and that procedure over the last number of years. I can assure you, for my part, there will be no lack of political will. I hope that even apart from the details, that you get a sense this morning of the kind of person that I am, but also of the approach that I will bring to this issue, because the rule of law and respect for it in our union is really the basis of everything else. If we don't have respect for the rule of law, then everything else begins to fall apart. And so we cannot allow an à la carte approach when it comes to rule of law in member states throughout the European Union. And so I assure you of the political will. I assure you of my willingness to look at new ways of doing things, to strengthen our approach, to ensure that there is uniformity and consistency. And again, in direct dialogue with many of you, you did raise concerns about what you would regard as lack of consistency. My approach will be evidence-led. It will be based on the facts. It won't be based on any preconception or any prejudice.
Thank you, Mr. McGrath. Your follow-up question, Mr. Arvanitis.
Now, within your remit, we have some challenges, traditional, as it were, but new ones. We have AI going everywhere. We have disinformation, oligopolies in the media. We have also wiretaps with different kinds of software, such as Predator and Pegasus. We have a rise in Euroscepticism, and some people are moving away from our common values. So we are expecting the EU to accede to the ECHR. So in this whole climate, what are you going to do in order to curb those reactions that are in place and move forward with a better toolbox in order to protect the democracy and the rule of law? Thank you very much.
I think the proposal for a democracy shield is very important and is an overarching framework within which much of the other work that we will be doing will sit within. And I look forward to working with all of you in relation to the development of this democracy shield, because it will seek to address the very issues that you have highlighted there. And there are many, many threats to our democracy. Yes, some of them are external to our borders, but they're not all external to our borders. If we are to be honest with each other, there are threats to democracy within the European Union, and we need to deal with those in a very effective and a very forthright way as well. So for me, the development of this democracy shield is not some abstract theoretical concept. It has to be real, it has to be tangible, and it has to make a difference. And it has to get down to the level on the ground of where our citizens are at. Because if they see us making practical changes that can restore their faith in democracy, then I think this Parliament and all of us will be the richer for it.
Thank you, Mr. McGrath. And now the floor goes to ESN, Mrs. Khan, Mrs. Marie Khan.
Yes, thank you, Mr. McGrath. I would ask my first question in my native language, German, just for your translation.
My first question relates to the Digital Services Act, which has been criticised as being censorship by many people. And in Germany, this regulation has led to a situation whereby people can conduct searches of the internet, and the head of Respect has had contributions put up which are not deemed to be against the law. This, I think, is an intervention in freedom of expression and democracy. And you talked about the rule of law in glowing terms. How would you prevent this massive intervention into freedom of expression coming about if things continue along the line that they're going along?
Thank you very much, Madam Khan. And I think it's important we are clear that the Digital Services Act and all of the strands within it, with the exception of illegal content online, is not about content moderation. It is about ensuring that there are tools in place to identify systemic risks, tools such as fact-checking, tools such as media literacy, tools such as empowering our citizens to themselves identify misinformation and disinformation. So it's about empowering our citizens while, of course, ensuring that at an EU level and within the national competent authorities that we do have a framework to protect people online. But I want to assure you of my absolute commitment to protecting freedom of expression as a fundamental right. The DSA is not about censorship. I'm conscious that the DSA, of course, comes under Executive Vice President Verkunnen, but we will be working very, very closely together in respect of the implementation of the DSA, and in particular tackling issues like disinformation and also implementing the European Media Freedom Act, which I believe is important. We have, as you know, the 2008 framework decision on combating racism and xenophobia by means of criminal law. This regulates the criminal response to racist and xenophobic hate speech and hate crime. And I know in the past mandate the Commission has made an effort to finally get all Member States in line with these standards in their criminal laws. Just to say that freedom of expression, it falls to me as Commissioner-designate with responsibility for the Charter of Fundamental Rights to ensure that that is respected and upheld. And we have to achieve an overall balance, but it is not an absolute right. When it crosses certain lines, then we need to have a system to intervene and respond to protect our citizens.
Thank you. Mrs. Khan, your follow-up question.
To go on with the DSA, the former Commissioner Terry Breton had a number of clashes with Elon Musk concerning X and its apparent lack of content moderation. Breton even went as far as to propose large fines for X if it did not comply. Elon Musk has always made it clear that he stands for free speech and freedom of expression, a view that is shared also by my party and also by my citizens in Germany. Therefore, I'd like to ask you, will you use the same aggression to force Musk and X to comply with the DSA? What will be the consequences for X if they refuse? And lastly, would you ban it from being used in the European Union if X does not comply? Thank you.
Thank you for your follow-up question. And there are very extensive powers within the Digital Services Act that in certain circumstances can be deployed by the relevant authorities. And as you know, we have the 2022 Code of Practice on disinformation, which is going to be converted into a code of conduct on disinformation. So I have a wide enough brief and issues to work with, but the core implementation of the Digital Services Act does come under my colleague EVP-designate Verkunnen, and I look forward to working with her and to supporting her in her work and ensuring the full implementation of the DSA, which I think the achievement of which was a very significant milestone by this House and the co-legislators.
Thank you, Mr. McGrath. Now we have completed the first round of political coordinators, and now I pass on the hammer to Chair Cavazzini.
Thank you. I will take it with pleasure. So stick to your time, please. Thank you so much for your discipline. We start the second round of political speakers. You're all aware it is now without a follow-up question, so 1 minute question time. Please stick to your time, and then a 2-minute answer without follow-up question. We start for the EPP with Dora David.
Dear Gwit, Mr. McGrath, the Commission's recent digital fitness check highlights harmful practices consumers face online, potential gaps in legislation and ineffective enforcement. Although the fitness check didn't focus on minors specifically, but minors also face many of the highlighted practices and more because the internet was not designed with children in mind. So, Commissioner-designate, what will you do to protect minors against the risks they face online? What will be the scope of your actions, and when will you take them? And how will you ensure effective cooperation between all the responsible authorities to ensure swift enforcement and to keep up with technological developments? Last night, I had a quick chat with your AI-generated avatar on a really cool website, and he basically said he would improve digital literacy and child safety features, create a task force for swift enforcement, and propose legislation within the first 6 to 12 months of the mandate. His answers were a bit generic, so I'd be interested in what the real Commissioner-designate would do. Thank you.
Thank you, Madam David. I'll try to do a little better than the AI-generated avatar, if I can, but can I just acknowledge the priority that you have afforded to this issue, the protection of minors online, and it is one that I share, and I'll work with you in relation to this issue. We all know children are very active online and often are the early adopters or the first adopters of very new technologies. The purpose of the Digital Fairness Act when it comes to minors is not about replicating anything that's done in any other legislation. The DFA is about dealing with gaps that are there in the protection of consumers in a digital space, including the protection of minors. So issues not covered by existing legislation, such as video games, for example. Specific concerns have arisen with the sale of virtual items using in-app currencies, for example. Another problem concerns gambling simulating features, such as loot boxes and video games, which are virtual items to give randomised rewards. We would be naive to think that the preeminence of these features and games are not having a long-term impact. I think that they are, and I think we need to be clear-eyed about the risks, and we need to respond to those risks as well. And moreover, many social media influencers have a young audience, and their content could include endorsements of vaping, plastic surgery, unhealthy foods, and we just have to ask questions about whether there needs to be some oversight or some regulation of all of those areas. I will ensure that the Commission fully supports in its coordination role joint enforcement actions of national authorities at an EU level. Next year, I'll present the results of a scientific study and experiment on marketing techniques that adversely affect the purchasing behaviour of children in online games. So we need to work through the detail of how we are going to protect children online in the DFA, but it's a piece of work that I look forward enthusiastically to working with you on.
Thank you very much. For the SND, Chloe Riedel, please.
Thank you very much. I didn't speak to your AI avatar last night, but maybe I should have done. My question focuses on the European Public Prosecutor Office that has proven very effective in protecting the financial interests of the EU over the last few years by billions of euros. But its workload has significantly increased in the past. This Parliament has repeatedly called for extending the EPO's mandate to include, for example, the crime of sanction evasion and circumvention. New competences in this field could significantly improve criminal prosecution and the effective enforcement of criminal sanctions across the EU. So my questions are the following. Will you commit to significantly push for the increase of the EPO's resources for it to be able to carry out its tasks? Will you ensure that a revised EPO regulation will be adopted before the next MFF? And finally, do you support extending EPO's mandate to sanction evasion? And what steps will you take toward reaching unanimity in the Council in this regard? Thank you.
Thank you, Madam Riddell, and I do agree with you about the success of EPO. I think it does really excellent work, and I welcomed the fact that it is included within the mission letter, and particularly on the issue of having the necessary reflections on the possible extension of the competence of the EPO to other cross-border serious crimes in addition to fraud. In particular corruption that impacts union funds and cannot be handled alone by member states, as is so often the case given the transnational and highly complex nature of these crimes. So I will do all that I can to work with you to bring about a stronger and a more independent EPO. And so in that regard, I would like to accelerate the revision of the EPO regulation, and that will involve looking at a number of different issues, including the rules on the EPO's competence, an assessment, for example, of whether such rules are sufficiently clear and comprehensive to ensure an efficient delivery of EPO's mandate, or do they need to be changed in light of the EPO's competence to other criminal offences. We need to look at the procedural rules on the EPO's investigations as well. EPO's governance and data protection regime should be part of the revision, and of course EPO's relations with its partners both within the EU, notably the Commission, OLAF, Europol and Eurojust, but also outside the EU. And I will do all that I can to ensure that EPO has the appropriate level of funding to effectively do its work, and I will support member states as well in bringing forward national measures that they can implement to protect the EU's budget. So I think EPO is doing very good work. I think the extension of its competence is something that I would support, and look forward to working with you on the detail of that.
Thank you. For the EPP, Adrian Vázquez-Lázara.
Comisario designado de un país que tiene opt-out.
Commissioner.
Start my time, please. Como comisario designado.
You're Commissioner-designate from a country that has an opt-out when it comes to internal justice, so you have a real requirement to defend all of this and active necessary. I mean, as you know, there are some member states who attack the system and also undermine the separation of powers. They adopt tailor-made laws in their countries, and they, for example, keep justice ministers or judges who are themselves on trial. They also take over state television and impose an editorial line. So you have all these attacks going on, but the Commission is often very slow, and sometimes it looks like double standards depending on which government is in power. Now, to avoid this idea of double standards, what are you going to do? I mean, could you come up with clear recommendations in all of these situations in the future Rule of Law report? Thank you.
Thank you, Monsieur Vázquez-Lázara. First of all, in relation to Ireland, of course you identify correctly the protocol that is there, but I would also point to the more recent approach of Ireland when it comes to a range of files, the e-evidence regulation, the transfer of criminal proceedings regulation. So wherever possible and in line with the Irish common law system, for Ireland to opt into some of the existing and any future instruments of criminal justice cooperation is something that I will encourage. And I know that Ireland is now on a pathway to joining EPO, and I look forward to working with the Irish authorities to make sure that work is concluded. I know the intention is to do it before the Irish presidency, which happens in mid-2026. The question of double standards, again, to me, it really doesn't matter who is in power. There will be no double standards when it comes to my approach on the rule of law issues. I know this is a political chamber. Perspectives will vary. I got a clear sense of that when I met with many of you individually, whether your party was in opposition or in power. And of course, I will listen to everyone and hear their point of view. But I will have to be guided by the evidence and the facts that I see when it comes to the rule of law report. So I think investing appropriately in the rule of law report, ensuring that it remains at the heart of our approach to rule of law. We are committed to adding the single market dimension, which I think is important, because I know that certainty and trust and confidence is a really important factor for businesses who are deciding to invest in another member state, or indeed to trade on a cross-border basis. So that is important, but fundamentally to give you that reassurance of a very impartial and even-handed approach to all rule of law issues in member states, irrespective of who comprises the government.
For PFE, Pascal Pierre.
Je vais m'exprimer en français, Monsieur le Commissaire.
I'll be speaking French, Commissioner. Commissioner, looking at your written answers, the European Commission will be trying to protect democracy, transparency, and the independence of the media and the rule of law. In order to do that, we've got this European Shield for Democracy, which is intended to come about. Now, if I understood you correctly, your objective is to fight foreign interference, to vaccinate, according to von der Leyen's way of putting it, the European Union against disinformation and hybrid threats. How will you guarantee that the European Shield for Democracy will not stop the freedom of thought of the people? And what about the alarm raisers? And we need to look facts in the face. What justifies the fact that this non-elected commission will be taking up this role to defend democracy?
Thank you for your question. And I think fundamentally the answer is that democracy is a value, a founding value of the European Union in Article 2 of the treaty. And so upholding and protecting democracy in all respects is an essential part of the work that we do, and is certainly going to be an essential part of the work that I do. The Democracy Shield is an important initiative. It will have a number of different elements, as you know, countering foreign information manipulation and interference and disinformation. It will include measures to preserve the fairness and integrity of elections and strengthening the democratic checks and balances. And I look forward to the conclusion of the report into the European elections that were held earlier this year as well. I will support the co-legislators to find agreement on the update of the European political parties and foundations regulation. It will also put a strong focus on societal resilience and preparedness, including through increased digital and media literacy. And that's where many of the issues that you have touched on there are important. But finally, and most importantly in many respects, it is about putting the citizens at the heart of our democracy, embedding citizens' participation and engagement in our work, instilling a true and a lasting culture of participative democracy. But there is no attack on freedom of thought whatsoever. We have the Charter of Fundamental Rights. It must be upheld. It is EU law, and it will fall to me as part of the annual reporting mechanism, which will now move to a monitoring basis to ensure that the Charter, in all its respects, is fully respected and implemented.
For ECR, Asita Kanko.
Mr. McGrath, since its creation, Europol has received strong support from the member states and from this parliament. I myself am a strong supporter of our police forces. However, good police work is wasted if justice doesn't follow. The police need to see that their work is leading to change. People need to see that justice is being done. In your written answers, you elaborate on Europol-Eurojust cooperation to protect our citizens. Can you tell us more on how you will support the work of Eurojust to make justice work? Second, I care a lot about women's rights. Sadly, the fight for women's rights is not won yet, not outside Europe and also not inside Europe. We saw what Hamas did to the Jewish women. We saw the troubling images of a girl defying the despicable morality police in Iran. We know that Sharia courts do exist in Europe. Everywhere, rape crimes are too often unpunished. What will you do to make sure rape is criminalized equally all across the EU and there is one justice system for all women? Thank you.
Thank you, Madam Kanko, and I know this is an issue you're very passionate about, and we spoke about it when we met in advance of the hearings. And I want to acknowledge all of those that have worked on the Violence Against Women directive, and I want to acknowledge the work of, for example, Frances Fitzgerald from Ireland, who was a parliamentary rapporteur on that file, and I think it did result in a significant breakthrough. It's not the end destination. There is more work to do, but it has allowed for the adoption for the first ever Violence Against Women directive at an EU level, and that was a very significant milestone of which I think everybody can be proud. Comprehensively covering all areas of prevention, protection, support and access to justice. And the Commission and this House, I know, did all that it could at the time to ensure the inclusion of a definition of rape based on the lack of consent in this directive, but it was not possible to achieve that at the time. The Commission can encourage Member States to introduce the concept of consent in their national definitions of rape when transposing the directive, and we would encourage that. It is an abominable crime, and it is important that there is uniformity and consistency across the Member States in terms of the work in that regard. If, following implementation of the directive, it appears that further action is needed, I would also consider a proposal adding gender-based violence to the list of Euro crimes, and I will be working very closely with Commissioner-designate Brunner in his work in that regard. I'm conscious of time, and I want to just acknowledge the second issue you raised of Europol and Eurojust. I think one of the real innovations has been the establishment of joint investigation teams, and I want to assure you that I will be following through on all the opportunities that are there to increase the cooperation between Eurojust and Europol, both of whom do excellent work.
For Renew, Svenja Hahn. Thank you very much, Commissioner-designate, for jumping so effortlessly between the broad topics of your portfolio. I would like to talk about more of the single market portfolio, something we haven't talked so much about yet, particularly simplification and that regarding the digital fairness rules. I was very pleased to see that in your mission letter there are a lot of issues that are very dear to my group, particularly reduction of bureaucracy, simplification, streamlining, because I think we need a turnaround when it comes to regulation, and it needs to be Commission and Parliament and Council to work for a real change. And you yourself said, looking at the Digital Fairness Act, we need to complement it with existing laws. The fitness check we saw only assessed 3 fields, but there are rules in place for many other areas. So I would like to know a bit more, how do you tackle the task of developing a Digital Fairness Act without creating a comprehensive new law, duplicating existing rules, and where would you see a potential to cut red tape? Thank you very much.
Thank you very much for your question, and I do believe that the Digital Fairness Act can make a contribution to the overall agenda of the Commission and indeed the Parliament to implement simplification. And it was indeed another aspect addressed in the recently completed digital fitness check of EU consumer law that you have referenced in your opening remarks. For example, in the area of consumer information, the fitness check identified scope for simplifying the information obligations in the case of purchases of digital content in video games and in-app purchases. That's just one example. There's a much wider question about simplification, and there are many measures within my portfolio where I can make a contribution. The upgrading of digital company law, the introduction of the 28th regime, for example, the manner in which we implement the Corporate Sustainability Due Diligence Directive, just to name a few examples. And the digitalisation of justice generally, I think, will offer significant opportunity for cost reduction and reducing the burden of administration as well. The Digital Fairness Act is not about layering additional requirements that are already in other bodies of law. I think the legal acquis that is there is currently missing coverage in respect of certain digital activities, and for consumers in particular, and hopefully we'll have an opportunity to go into them around the dark patterns and the addictive design and the personalised behaviour, the role of influencers. I gave the simple example earlier on of, you know, we all sign up to subscriptions. It seems to be very easy to sign up. It's really difficult to cancel a subscription. Can we deal with issues like that? So simplification will have benefits for consumers, but it will also have benefits for businesses. And I'll be looking at every opportunity available in the Digital Fairness Act and across the full suite of files that I have in my portfolio for simplification opportunities.
Thank you. For SND, Katharina Bali.
Dear Mr. McGrath, first of all, I would like to know if we can expect consumer protection to be added to your title as Commissioner, which we would find important. And secondly, I will give you the opportunity that you just asked for. Business models on the internet are partly based on what experts call the addictive design, you mentioned it, and research shows that the overuse of such platforms can cause serious harm to physical and mental health, not only with minors, by the way, as well as material damages. So, and of course, the big tech businesses behind that are fully aware of these effects. So you propose a Digital Fairness Act. Do you commit to include concrete legislation to protect Europeans from such addictive designs? And doing this, of course, means tackling the business model of big tech. So as a commissioner, do you commit to take on those very powerful players?
Thank you very much, Madam Barley. And of course, the addictive design element of the Digital Fairness Act proposal is called out in the mission letter and in the political guidelines. So yes, there will be concrete measures which we will have to develop together to address addictive design, which can come in many different forms. But we know that the whole purpose of many of the online platforms, many of the products online is to keep you there, is to keep you online and to keep bringing you back. So features like infinite scroll, autoplay, constant notifications are all designed to bring you back onto the platform. And so that does require attention. It is complex. It is not going to be easy, but we will need to bring in measures to protect consumers in that regard. As you know, the President has also confirmed there will be an EU-wide inquiry on the impacts of social media on well-being, and we must make full use of the Digital Services Act to ensure that large social media platforms take measures to protect minors as well. In my view, there is room to strengthen the protection of consumers online, and that is what the Digital Fairness Act will seek to do. It will not duplicate, and I want to give everyone this reassurance, the body of work that has been completed by this Parliament and the Council and Commission over the last number of years. And a lot has been done in the digital space. The DSA, the DMA, the AI Act itself, the General Product Safety Regulation. There are so many different instruments, and many of you have raised concerns about duplication and layering more requirements. This is about closing gaps that are there, which will help to protect and support consumers in their decision making and in the choices that they make. And it will also ensure that we do help to protect minors online. And I hope that that is an issue that we can all unite around in our work on this important file.
Now for the EPP, Michael Warikkiewicz.
Mr. Commissioner-designate, thank you for your strong commitment to protect the rule of law. I have three issues I would like to address. First, I'm getting back to the means that you will use to protect the rule of law and to prevent member states from backsliding of democratic standards. I refer obviously to the obvious examples like Orban's regime in Hungary, but also to other states, less obvious examples like Slovakia or Spain, where we should also protect the rule of law. So the fundamental question arises, are you going to use the existing toolbox, or maybe you are planning to improve it, and do you consider any new legislative proposals? Second question, erosion of the rule of law principles threatens our common single market. How do you plan to address those issues, especially in Hungary, which uses protectionist tax policies? And third question, what is your assessment of the situation of democracy and the rule of law in Western Balkans? Thank you.
Thank you very much for your question. In relation to the rule of law, I think one of the real strengths of our approach is that it applies to every member state, and every member state is subject to the annual rule of law report, where an assessment is carried out and where recommendations are made. And I want to strengthen the follow-through, the implementation, the action. The rule of law report is not an end in itself. It is a very useful tool. It is preventive in nature. It has led to positive change, but I do think there is more that we can do. You asked me, will I use the existing toolbox or create new ones? The answer is both. I will use the existing toolbox. It is there. The conditionality mechanism, for example, is a permanent feature. That does not end when this MFF comes to an end in a number of years' time. But there will be other opportunities that we have to strengthen and build a closer link between compliance with rule of law and access to EU funds. And that is the space where work needs to be done. There's no definitive answer at this point in time as to how that will be done, because I have to engage and negotiate with colleagues across the Commission, in particular the Commissioner for the Budget, who has obviously very direct responsibility in terms of the MFF. On the single market dimension of the rule of law report, as a former finance minister, I understand the way in which companies make decisions when they're trading internationally. They want to have predictability. They want to have certainty. They need to have confidence in the judicial system. They need to know that contracts they enter into with a third party in another member state will be enforced in that country's legal system. So those are the very issues that the single market dimension of the rule of law report will add, and I look forward to doing that. And of course, in relation to the Balkans, I know in recent weeks, or last week, the 2024 enlargement package clearly highlights the progress and the outstanding issues in each country. But I'll be working with the Commissioner for Enlargement and we'll continue to consider expanding the rule of law report to other candidate countries.
Thank you. For the Greens, Kim van Sparentag.
Thank you, Chair. Dear Mr. McGrath, I will follow up to some of the previous question on the Digital Fairness Act, because you've mentioned minors a lot, but no one's self-discipline can beat the manipulative, addictive tricks we face online. And there is clear proof of the negative effects of addictive design and excessive screen time. It creates anxiety, depression, even effects on our brain development and attention span. So it's high time we gain control over both our own time and our own timelines again. And the European Parliament has called on the Commission to be the first in the world to tackle the addictive design of online products and services with legislation. And now it is up to you to tackle this problem for our generation and the generations to come. And you say it is complex, but if we started to look at digital products and services as the products we use like the most in our lives, then maybe we can actually do something. So will the announced Digital Fairness Act contain clear binding rules against addictive design for consumers of all ages? And will you ban the most harmful and addictive design features, such as the endless scroll and autoplay of videos? Thank you.
Thank you. For the EPP, Dirk Gottniek.
Thank you.
Sorry, no, of course you have to reply.
Thank you, Madam Van Sparentag. And yes, we can do something. And we will do it together when we bring forward this file. We're going to have to work really closely. I understand the business model of big tech and of these firms, and they want to keep people online constantly, including our children, and that is how they get more money for the advertising that is spent on their platforms. So we understand the model, and we are going to have to address this in the Digital Fairness Act, and I can assure you that we will, because there are harmful functionalities on these platforms that have an impact on on children in particular during those formative years, and the effects can be lasting. And in many respects, the studies are only happening now, but I think we have enough evidence to allow us to take action in that regard. Yes, the Digital Fairness Act will cover all consumers, irrespective of age. So I think it's important to put that on the record, but it will certainly pay special attention to the protection of minors as online consumers, and that is what they are. They are part of the near 450 million consumers in the European Union, many of whom are online every single day. In more general terms, I think it's important to make the point that while we already have a comprehensive suite of consumer protection legislation in the EU. It applies to all market participants, but it is technology neutral, whereas in recent years, the growth and development of commerce online, of games online, has just been exponential, and that has created issues that we need to examine. So this file will be a priority for me, and I will work very closely with you on the detail and the specific measures, but I think we do share a common objective.
Thank you. And now for the EPP, Dirk Grotnik.
Thank you, Chair. Mr. Commissioner-designate, looking and listening to all the priorities that you have for democracy, justice and the rule of law, your friends in the IMCO committee will hope you also spend time on consumer protection and competitiveness. I'm here. Because as you know, the European market is being flooded with billions of packages from China. Meanwhile, customs authorities and inspections agencies lack the capacity to properly check for health and safety standards. This exposes consumers to potentially dangerous products, but also pushes local retailers out of the market. It is a massive challenge for consumer protection and competitiveness. So the questions would be, first of all, the responsibilities in the college are shared. How will you come to an integrated approach with your colleagues on this? What can we expect in terms of cooperation inside the college? Second, what does your roadmap look like on consumer protection? I think it was asked already before. What concretely, when can we expect proposals? And thirdly, lastly, what actions on the compliance issue, market surveillance issue, can we expect from you regarding third countries?
Thank you.
Thank you, Mr. Hotink, for these questions. And I will be working very closely with EVP Designate for Cunnin in relation to e-commerce and the issues that flow from that. And product safety is an area where we have much work to do. I welcome the General Product Safety Regulation. Great to see that it's about to come into effect next month. We now need full and consistent implementation of that across the European Union. So we need a consumer protection network, cooperation network to coordinate and work very closely together. The European Commission will ensure that there is coordinated action, including coordinated enforcement action where that is appropriate. But I do believe we need to review the Consumer Protection Cooperation Regulation, and in my opening remarks I touched on the need for a new consumer enforcement initiative. So at the moment the powers rest at Member State level. That works well in many respects, but I think there are breaches that cross a certain threshold which require an EU-wide response. We can do that to an extent through coordinated responses of the national competent authorities, the surveillance authorities. But I do think centrally there is a need for investigative and enforcement powers. So for me, bringing forward the review of the Consumer Protection Cooperation Regulation will be a priority, and I would like to work with you and your colleagues to scope out what an enforcement initiative might look like in that respect, because I do regard it as a priority. I was looking at the stats, and data in the EU Safety Gate portal show that China accounts for about 50% of notified dangerous products in EU markets. And we all know the platforms that are flooding the EU with products, much of which does not meet basic EU safety standards. There is improving cooperation with the Chinese authorities. I want to examine that to see how we can improve that further and to stop this supply at the source. They should not be coming on the online marketplace in the European Union.
Thank you. Thank you. Now for the left, Luke Flanagan.
The Commission recently announced that it will begin infringement proceedings against Ireland for not carrying out market surveillance on construction products, saying several thousand houses in Ireland suffered very serious damage as a result of defective products. And also the Commission said the limitation of market surveillance activities to on-site measures endangers the free circulation of safe construction products in the EU. Due to the defective construction products, several thousand houses in Ireland suffered very serious damage. However, your government has publicly said they will strongly defend its position. The Department has said it is actively undertaking market surveillance of construction products in compliance with EU legislation. That's not true. In the mission letter from von der Leyen, she says you will ensure the EU continues to be a global standard bearer in terms of protection and product safety. You said here today that our voices will be heard, and also said that the rule of law must be upheld in all member states, also that you'd be an honest broker. How can we trust someone from the poacher family to be a gamekeeper?
Thank you for your question, Member Flanagan. Yes, I am aware of that formal letter of notice that has gone from the European Commission to the Irish Government back in July in relation to alleged failure to fulfil obligations under the Construction Products Regulation. You have summarised there the position of the Irish Government and they have responded to the Commission, and of course the Commission now will have to consider that response, and the Commission will, on the basis of the evidence, objectively make a decision whether or not that file advances and moves into a reasoned opinion and a more formal infringement proceeding basis. But for me, the fundamental issue is that the necessary reform that had to take place is now happening in Ireland. And I welcome the fact that in 2022, the Regulation of Providers of Building Works and Miscellaneous Provisions Act was enacted, a very important piece of legislation, which is to develop and promote a culture of competence, good practice and compliance with the building regulations in the construction sector. And this will involve a statutory register, for example. And the Government is also progressing the establishment of an independent building standards regulatory authority. I think that is a necessary and an important reform. And of course, coming from Ireland, I am all too well aware, as I know you are, because you represent many of your constituents who have been devastated by the defective concrete block issue. And the focus, I know, of the government in Ireland is to try and support people through the remediation scheme. There will be different views on the nature of that scheme, and I've no doubt it will be an issue that will be debated in the course of the next number of weeks in the general election and by the governments, the parties that will form the next government. But certainly I think it's important that that scheme is implemented, that people are looked after. I know that many of them have had their lives and their homes devastated, and it's important that they do receive full remediation.
For the S&D, Pier Francesco Maran.
Thank you. Mr. McGrath, I go back to the question from my colleague Barley. Can we expect the consumer protection will not only be a priority but be added to your title as Commissioner? The next consumer agenda will be key as consumers are increasingly faced with misleading commercial practices, both in online and physical marketplaces. One example is dynamic pricing that was recently used in the sale of Oasis concert tickets. In the Digital Fairness Act, will you look into regulating dynamic pricing, especially in the field of culture and entertainment? Another worrying trend is a shrinkflation or skinflation, where quantity or quality of goods is reduced but the price is not changed. Will you commit to enforce or revise EU laws to ensure that sellers declare instances of shrinkflation or skinflation like it still happens in some member states? Thank you.
Thank you, Mr. Maran, and I do apologise to Madam Barley for not answering the question about the title. And I hear you. It's not my decision, of course. It's a decision for the President and the College. As you know, the DG that I hopefully will be working with is DG Justice and Consumers, but whether it's added to my title as Commissioner is above my pay grade. But I hear what you've had to say in that regard. Thank you for your question on dynamic pricing. There's been a big debate about this in Ireland as well, in the context of the concert ticket sales for Oasis, and I know the national body there has commenced an investigation. Of course, dynamic pricing is not prohibited in EU law. Traders can freely determine the prices for so long as they adequately inform consumers about the total price. But there may be aspects of dynamic pricing that do constitute an unfair commercial practice, and I think it's in that space where the current examination may well be taking place. I want to look at this in the context of the Digital Fairness Act, and I will work with you and with all colleagues, and I'm open-minded as to what solution we need to put in place, because it is an issue, particularly in the event ticket sector. I think that is quite different, where over the space of 2 or 3 hours the price can multiply 5 or 6-fold. In relation to the other issues, I think when it comes to shrinkflation, which we have all seen, I think, in recent years, the price indication directive is important. That must be fully implemented. It allows consumers to weigh up the different options in their products so they can see the price per unit. I think that's very important, and I think the powers are there to deal with that at national authority level. I have to say I wasn't familiar with skimpflation, but I had to look that one up in my preparation over the last number of weeks. But again, I think there are powers there, but we do stand ready to do more if that is required in the context of the Unfair Commercial Practices Directive. It's important there is full transparency for consumers in relation to any changes in the quality or the composition of products. That must be fully open and transparent.
Now for the PFE, Martin Frias.
Señora Presidente, gracias.
Thank you very much. Thank you, Mr. McGrath, for your time. 2 questions. In your written answers, you said that freedom of speech is very important to you, but you didn't mention it in your response to the formulaic questions in the questionnaire. In fundamental rights, Member States and the Commission can end up legislating on hate speech in a way which undermines freedom of speech. This has happened in Ireland, where last month a proposal in relation to hate speech had to be withdrawn. In the annual State Rule of Law report, you refer to implementation, but how can we ensure that that report is not used as an ideological weapon against Member States governments which have been democratically elected? That has happened in the past against Poland and Hungary, and in the latest report, Italy.
Thank you very much, Honourable Member. It is not about ideology. It is about our values, and it is about ensuring that everyone in the European Union is respected as an equal. And in the achievement of that, we have to pay particular regard to minorities. And we have to ensure that the values of the European Union are fully upheld for them in every respect. I will always defend and protect the Charter of Fundamental Rights. It is going to be a core part of my job, and that, of course, involves freedom of expression. But we also have to be honest and acknowledge that there is a balance to be struck between freedom of expression and addressing hate speech, hate crime, and indeed disinformation as well. And I know that the Commission proposed in 2021 that the Council adopt a decision to include hate speech and hate crime in the list of so-called EU crimes in the treaty which are particularly serious cross-border crimes. But that requires unanimity, and the required level of support was not there. And of course we will continue to observe developments in the Council and stand ready to explore alternative ways within the scope of the existing treaty provisions. But I can assure you it will not be at the expense of the fundamental freedoms that we afford to all EU citizens, including freedom of thought, freedom of expression. But there are boundaries, and the boundaries are that we have to ensure that we respect everybody within the EU, and that we particularly respect minorities who are more vulnerable than others in their day-to-day lives.
Now for ECR, Dennis Nesci.
Grazie, Presidente. Thank you, Chair. Commissioner-designate, well, in your mission letter, it says that your task is to integrate the single market into the rule of law report to deal with legal issues that relate to businesses, and in particular SMEs that operate across borders. Could you tell us about the clear measures that you intend to promote the legal certainty for these businesses in the European Union? And then you were talking about candidate countries and saying that they would need to adhere to these standards. What will you do to ensure that? And then finally, on the annual report, would you commit to ensuring that the upcoming reports from the European Commission be evidence-based and not drafted in to be consistent with ideological positions from NGOs? Thank you.
Thank you, Mr. Nesci, for your question. Yes, I can commit that the rule of law reports under my stewardship will be evidence-based, and of course we do listen to many voices when the rule of law report is being prepared, including NGOs, but also the national authorities. Their voice is important, and the draft of the country chapter, as you know, is shared with the national authorities in advance, and their input will be very carefully considered, and they will be given a very fair hearing and every opportunity to address any issues that they think are factually incorrect in the context of the report. In relation to the candidate countries and the single market dimension, as you know, the annual report earlier this year included Montenegro, North Macedonia, Albania and Serbia for the first time in the annual rule of law report. I think that was an important signal, and we look forward to extending the rule of law report to include other candidate countries as and when they are ready. On the single market issue, I think it is important that we move ahead quickly with that. So I want to confirm that the next iteration of the annual rule of law report will involve a single market dimension. I believe it does need to address the issues of legal certainty, of confidence in the judicial systems, contract enforcement and so on, so that we strengthen our single market. And at a time when the European Union is trying to improve its competitiveness, there are barriers within the single market to the conduct of trade, to the conduct of commerce, arising from rule of law issues. We also have to be honest about that, and certain infringement proceedings have been taken by the Commission in respect of specific matters relating to that.
For Renew, Ilhan Küçük.
Well, thank you so much. Mr. McGrath, you touch upon the very important issues related to democracy shield, threats within European Union, but also threats within outside European Union. And I want to deepen my question a bit to fundamental values of the Union, and particularly the Article 2 of the Rule of Law report. Sometimes Parliament, not sometimes, but usually Parliament was calling for consistently review of Article 2. In addition, across the Union, it's becoming evident that from administrative proceeding point of view, the organization of free and fair elections are an extremely important element when it comes to checks and balances within the institutional setup of the European Union. Would you be looking at this within the scope of rule of law report, or would be the threats of free and fair elections be addressed within the European democracy shield as severe risk of our democracy?
Thank you, Mr. Kuchuk, for your question. As you know, the rule of law report currently deals with 4 important pillars around judicial independence, media freedom, media plurality, the adequacy of the anti-corruption framework within the member state, the appropriate checks and balances at an institutional level within the member state as well. And what I've been asked to do in the mission letter is to include the single market dimension, so that will be a priority because I need to move ahead and give effect to that very quickly. And I also want to build that closer link between the rule of law recommendations and access to EU funds, because that is a specific commitment that I think is broadly supported across the House. We will keep the structure and the nature of the rule of law report under review, and if there are any changes that are appropriate and it would help to make the report more impactful, then I'm open to that. But I don't want to be in an endless cycle of report writing. I want action. I want implementation. I want to get things done, and I want to see improvements in countries where there has been slippage or backsliding in respect of rule of law. That will be my priority, will be to see action. Of course, when it comes to the Charter of Fundamental Rights, the Commission monitors the application of the Charter on an ongoing basis as part of its regular monitoring of EU law's implementation, and adopts annual reports on the application of the Charter, which will now move from being a thematic snapshot to now being a monitoring report. So we have to give thought and careful consideration to the nature of that report. And then, of course, we will bring forward on the issue of elections that you spoke about, which is so important, the European Democracy Shield. We will engage with stakeholders, including the European Cooperation Network on Elections, which I think is an important initiative as well.
Now for the EPP, Emil Radiev.
Уважаемый господин Маград.
Mr. McGrath, your mission letter has requested you to contribute to reducing reporting obligations by at least 25% and at least 35% in relation to SMEs. In your written answers, you have committed to this objective, and you have repeated that possible administrative burdens will be taken into account in order not to overburden companies that struggle with red tape. As Justice Commissioner, you will be overseeing implementation and enforcement of many recent acts, including the Corporate Sustainability Due Diligence Directive. In your written replies, you've mentioned that you see scope for creative, innovative work on implementation. How are we to understand this statement? As regards the Corporate Sustainability Directive, would you, for example, consider a grace period or postponing its implementation if it proves that such implementation comes across massive hurdles? How would you intend to solve the problem that the Commission guidelines for businesses will only come after implementation at national level? Can those guidelines be received earlier? Thank you.
Thank you very much for your question. My priority when it comes to the CSDDD will be to ensure timely and effective implementation of that. I do believe we need to pay particular attention to the relevant support measures that will be needed as part of the implementation phase. And we need to make it as easy as possible for companies to comply with the directive. And that is why we will need to provide every support possible, including detailed guidelines to make sure that the transposition and then the implementation happens in line with the timeline that we have set out. And as you know, it is a staggered implementation between July 2027 and July 2029. So it does take account of the capacity to prepare for new rules while ensuring that EU targets can be met. I think it's important that we provide the legal certainty that's needed. Many of these large companies are already having to comply with equivalent national laws that might not be of the same depth or standard, but they're having to comply with national due diligence laws. So I think it's important we give them the certainty that this is going to happen. The legislators have concluded their work, and now the focus has to be on the implementation of it as quickly as possible. That does mean consulting with stakeholders on the priorities of implementing measures such as guidelines, and also on the key issues to be addressed, including on the draft guidelines themselves. And I note your question in relation to the timing of the guidelines. In general, I think it's important that we provide the support measures as early as possible. So I will engage with the team in the DG in relation to that practical implementation, that we make it as easy as possible. And of course, this directive doesn't impose additional reporting obligations. They're already provided for in the CSRD.
Thank you. For the SND, Lara Wolters.
Yes, thank you. Over here. Also, some very concrete questions on corporate sustainability due diligence from my side. As just demonstrated, I think some are still trying to discredit this piece of legislation. Earlier today, you talked about a fresh look at company law, the manner in which we implement the CSDDD. You just said making that as easy as possible. So how do you view this debate? What side are you on? And concretely, how will you ensure the timely and effective implementation of CSDDD, including the related reporting requirements in CSRD that were just mentioned? Will you commit to dedicating more resources in the Commission on this than is currently the case, including for that very important development of those guidelines? Do you commit to the submission of a report by July 2026 on additional due diligence requirements for financial undertakings, including a legislative proposal? And then lastly, internationally, the UN negotiations on this, on an instrument on business and human rights, what will you do to advance that? Thank you.
Thank you very much, Madam Walters, for your question. You asked me where I stand on the issue of the directive, so at the fundamental level. So we must proceed. The directive is there. It must be transposed and it must be implemented. In doing so, we do have to provide as much support and assistance as possible to ensure it can be done seamlessly and efficiently. On the question of reporting, as you're very familiar, and I know you've done a huge amount of work on the directive. For reporting, the CSDDD relies on the CSRD and its associated European sustainability reporting standards, thereby avoiding duplication. And that's an important message that we give to those who are critical or sceptical of this proposal. It does avoid duplication for companies in the scope of both sets of rules. But I think it's important that we take a global lead in the European Union on these issues, on a sustainable business model being adopted by businesses that respects human rights and promotes the environment across the full supply chain of their operations. And I also believe that the CSDDD will have a wider impact outside of the European Union, not least because of the nature of the supply chains, but other jurisdictions that want to trade with the European Union will see this as a global leading implementation measure. And that, for me, I think is where really effective change can be brought about. So the focus will be on delivering the implementation support measures foreseen in the directive to facilitate compliance and support the companies in their sustainability transition, including the guidance documents, the model contract clauses, the single help desk. And I'll engage with you in relation to the timelines and the specific modalities of the steps we need to introduce, but we do need to proceed.
thank you. Just a little reminder, we're like running 20 minutes late, so I remind everyone to really stick to the time assigned to you. Now we come to Regina Doherty for EPP.
Thank you, Chair. Fáilte the Parliament the Europa, it's Mahan Rode go will to.
Welcome to the European Parliament. It is wonderful that you're here.
Ask you to contribute to reducing reporting obligations by at least 25% and 35% for our SMEs. And Mario Draghi highlights that there are areas where the EU should do less and show more self-restraint, because regulation is seen by more than 60% of EU companies as an obstacle to investment. And yet, at the same time, your mission letter asks you to present proposals on a new Digital Fairness Act, a new 28th legal regime, further regulation for e-commerce platforms, a new consumer action plan, modern product safety policies and updates to the GDPR Act, amongst other acts. And given the conclusions of Draghi, particularly regarding over-regulation and subsidiarity, how will you ensure that these reforms meet the aims of enhancing EU competitiveness and don't create new barriers and burdens on job creation and investors, whilst also protecting and upholding the rights of all of our consumers in the EU? So my specific question is, will you make a competitive test part of all new legislative proposals?
Thank you very much, Madam Doherty, for your question. And of course, there is that overarching obligation that all Commissioner-designates are being asked to comply with, and that is to make our contribution to improving the competitiveness of the European Union and to reducing the reporting requirements for SMEs by 35%. And as the President said in the guidelines, I and the other Commissioner-designates in charge will work with the Commissioner in charge of implementation and simplification to stress test the acquis and remove any obsolete, overlapping and inefficient rules. So that is a clear commitment. I'll also have regular dialogues on implementation with stakeholders so that we are aware of the realities on the ground. Also that we ensure through the new SME and competitiveness check that we avoid unnecessary administrative burdens, maintaining high standards. As you know, I intend to launch a Justice for Growth strategy that will look at civil law and company law, and one of the lenses that I will be using when I look at that is where are the opportunities to reduce red tape and make it easier for businesses to trade, because this is an issue that comes up very consistently. But to do that in a way that doesn't dilute rights, and I think it is possible to achieve that. So that high-level process on Justice for Growth, I think, will afford opportunities. I'm committed to the digitalisation of justice. I think there is a lot of potential there. I look at ways that we can help SMEs in particular. We have the Business Register Interconnection System. We have the unique European Company Identifier. When it comes to the CSDDD, my focus will be on guidance to support businesses in their compliance with as little bureaucracy as possible. And in the area of consumer protection, and I think we don't afford enough attention to this, by strengthening consumer protection, particularly around e-commerce, that is improving the competitive position of EU businesses so that there is a level playing field for them operating in the single market, which at the moment is distorted by the amount of unsafe product coming into the European Union.
Now for the non-attached members, Judita Lažáková.
Thank you very much. Mr. McGrath, I'm very pleased that protection of consumer and the rule of law is part of your portfolio, but protection of consumers is an area which is not very popular among advocates. Very often there are civil associations which represent citizens in courts, and justice is for those who are knowledgeable. Very often these associations do not even cooperate with lawyers, and these procedures are very often lost due to this reason. Some citizens lose even their houses. Are you going to develop some kind of initiatives so that these civil associations are subject to some kind of security, or there is some fund at the disposal of citizens who are damaged?
Thank you very much for the question. I believe that access to justice, whether it be civil justice or criminal justice, is a fundamental right that we must give expression to. And whether that be in the area of consumer law, to ensure that consumer rights are protected and upheld. And very often, people may find consumer law very complex. They can be bamboozled with detailed terms and conditions. And when they seek to vindicate their rights, there are barriers put in their way. And many people just give up. So that is why we need to make sure that at member state level, that the organisations that support consumers to vindicate their rights are supported themselves through the member state budgets, and we will do what we can through the European Union as well. I think that's really important, because I think some businesses can take advantage of that situation where some consumers are not well enough informed, or perhaps just not able to navigate what can be an overly bureaucratic or complex system of enforcing their consumer rights. So this is a part of the portfolio that I am really looking forward to getting stuck into. I think there's a lot that we can do to help consumers in the European Union. And as I said a moment ago, I think that will actually help businesses as well, because of the integrated nature of the global marketplace. And if we ensure that companies who are selling into the European Union are also subject to these obligations, and at the moment many of them, particularly in the area of product safety, are not complying, that will strengthen the relative position of European businesses in selling into the single market. And so I would hope to work with you on these issues, because I think there is an opportunity to make real progress for the citizens who we are here to serve.
Now for PFE, Andras Laszlo.
Mr. McGrath, what Madame Strick said about the Article 7 procedure against Hungary doesn't sound like rule of law. Greens want to be the prosecutor, they want to be the judge and jury, and they want to carry out the sentence. Does this sound like rule of law? Because to me it sounds a lot more like Soviet-style state trials, and something that is, unfortunately, Hungarians are already very familiar with. Second topic, there have been several high-profile murder and knife attacks committed by illegal immigrants residing in the EU, despite the fact that they have leave orders from member states. But authorities do not carry out these leave orders. So do you agree that this is a rule of law problem? What will you do to protect European citizens? And do you agree that member states should detain these people with leave orders until deportation? And third question is, Ursula von der Leyen was called on by the EU Ombudsman to release the text messages she exchanged with Albert Bourla, CEO of Pfizer. If the Commission President can ignore the EU Ombudsman, why shouldn't anyone else? Thank you.
Thank you very much for your question. I reiterate the basic point. The rule of law requirements apply to everyone. And it will give me no comfort or no joy to be using the various instruments that we have. They are currently being used. But if I need to do so, I won't hesitate in doing so, because if we do not have the rule of law in every member state, then that will encourage others to also backslide and to renege on their democratic obligations. So protecting our values, protecting our fundamental rights, supporting our democracy in every member state will be my North Star. That will be my mission. That is what I will seek to do every day in the course of my work. And the various instruments are there, but I also want to say my first port of call will be dialogue. With member states to engage with them, to challenge them, to hear what they have to say, but then to back that up with action if I believe that is warranted. To your second point, a crime is a crime. It doesn't matter who commits the crime. If a crime is committed within the European Union, then we have to make sure through the judicial and criminal systems in the member states and where we share powers at an EU level, that we have the appropriate tools to respond. We have now an asylum and migration pact for the European Union, and the focus should be on the implementation of that. But I do not believe that we should seek to be divisive, to set one group in society up against another group in society because a crime committed by one is more serious than a crime committed by another by virtue of their identity or where they come from. It is not. A crime is a crime, and it should be treated accordingly by the European Union.
For the SND, René Repassi. The time was over. Now we have the next colleague, René Repassi for the SND.
Mr. McGrath, your mission letter requires from you to help innovative companies grow by means of corporate law. In my eyes, innovative companies need investments without becoming prone to killer acquisitions. Steward ownership is a way to achieve this goal through asset locks and the separation of voting and economic rights. Germany and the Netherlands are currently considering the introduction of such new legal form. Will you commit to exploring changes in EU law to support the creation of such long-term oriented ownership models across member states and as part of the 28th regime, ensuring that asset lock provisions are created or at least protected at the European level? Do you consider the harmonization of elements of corporate forms, such as asset locks, next to an ambitious overall 28th regime? Would you commit to adjusting the EU Mobility Directive in order to protect national corporate forms for innovative companies with asset locks from abusive conversions? And finally, when working on the 28th regime, will you commit to present a legal form that cannot be misused in order to hollow out national co-determination rights, as it was recently allowed by the Court of Justice in the context of the SE?
Thank you, Mr. Repassi, for your question, and the bringing forward of the 28th regime is going to be an important piece of my work and will involve consideration of a number of the specific issues that you have identified there in your remarks. I think at a fundamental level it is about ensuring that where a company is formed in a member state, that it is fully recognised across borders throughout the European Union for the conduct of business. It is about bringing down barriers to the full operation of the single market. There are certain aspects of it that I think are pretty obvious. There are others that will require very careful consideration. A 28th regime should be set up fully online. It should benefit from the application of the once-only principle when setting up subsidiaries and branches in another member state, and it should no longer need to obtain an apostille. It should have a European unique identifier for companies, which provides a single identity and is based on a single registration and a multilingual digital EU company certificate. So these are issues that I think it should be relatively straightforward to reach agreement on. What I want to see in relation to companies in the European Union is that they can scale and grow within the EU. And for example, when we have entrepreneurs or we have high potential startups, we see too many early exits. And I think we need to look at the different mechanisms that will help to incentivise companies to remain in European ownership for the long term, to grow and develop and to become companies of a global scale. I know the issue of an asset lock is not a new phenomenon. It's an essential feature of non-profit entities, but with regard to companies, it can also be a way to retain capital for the long term. And that is so important because companies need to continue to reinvest if they want to grow to the next level. But I will work on the detail with you as we develop the 28th regime as a concept.
Now for the EPP, Ana Miguel Pedro.
Mr. Commissioner-designate, my first question is about the future scope of EPPO. Are there additional areas of serious cross-border crime you believe could be addressed to further protect the EU? And do you foresee any possibility to expand its mandate before the launch of the next MFF? Do you see a need to establish dedicated police units or other specialized entities to combat financial economic crimes affecting the EU budget as advocated by EPPO? The next topic I wish to address involves Russia's war in Ukraine. In light of this ongoing conflict, what measures can you take, perhaps in collaboration with EPPO, to enforce justice in cases of war crime? Can the EPPO help enforce sanctions to cut off funding that supports Russia's aggression?
And finally, do you anticipate any new legislative or non-legislative initiatives to improve cross-border access to justice and judicial cooperation within the EU? Thank you.
Thank you very much for your question. And if I start perhaps with Ukraine and the work that we are doing and where we need to do further work over the period ahead. First of all, on the question of accountability, taking discussions forward on the establishment of a special tribunal for the crime of aggression within the institutional framework of the Council of Europe is going to be a priority. So I'll work with you and with Member States as well as the High Representative to step up the Union support to Ukraine in the area of justice, because I think we can make an important contribution. On the issue of sanctions, as you know, earlier this year, the Union adopted a directive on the criminalisation of sanctions violations, and thanks also to support of this House. So I will make sure that the Freeze and Seize task force can take forward its work and explore all possible avenues to ensure a better enforcement of our sanctions, notably by means of criminal law. In relation to EPO, which you raised, and to say a quick word about EPO and Ukraine as well, as you know, under the previous Commission mandate, Eurojust and the EPO have already stepped up their support for Ukraine. EPO signed a working arrangement with the Prosecutor General's Office of Ukraine and the National Anti-Corruption Bureau of Ukraine. If necessary, I will ask from the Council the mandate to negotiate an international agreement with Ukraine on its cooperation with the EPO. I think that is an area where progress is possible, and we should seek to bring that forward. My priority now is to complete the evaluation of the EPO regulation and to bring forward a revision of that regulation dealing with the rules of EPO's competence, particularly the extension to the area of corruption on a cross-border basis, the procedural rules, the governance and data protection regime, and its relations with its partners both within the EU and outside the EU.
Thank you very much. For the Greens, Sergej Lagodinsky.
Well, thank you. Thanks so much, Commissioner-designate. First of all, I apologize that I didn't consult your avatar before asking you in person, but it's great to see you again. When I would sum up an important dimension of your future work, it would be accountability and transparency. And from that perspective, two questions. Number one, on accountability of companies. Lara Walters already mentioned we are looking now at the delay in implementation of CSRD by 17 member states. We are having a huge pushback by some member states on CSDDD, triple D. How will you ensure the proper implementation? You said you want implementation, but what are the instruments and what is the plan and the strategy there? Because you will be facing this resistance by member states in the future and already now. Furthermore, criminal responsibility, when we're talking about criminal prosecution of companies held liable for environmental damage. The 3 minutes that I have.
You have 1 minute.
Okay. Well, thank you very much. I will have the rest of the questions to your avatar.
Thank you, Mr. Lagodinsky, for your question. And you're asking for the detail of how we will proceed and ensure that the CSDDD is implemented. And in that regard, the focus will be on delivering the implementation support measures foreseen in the directive to facilitate compliance and to support companies in their sustainability transition. But this is work that must proceed. There should not be any reason for delay. This will include various guidance documents, model contract clauses for companies for their due diligence efforts, a single help desk to provide dedicated advice to the questions that will nevertheless arise. And all of these measures will bring additional clarity and legal certainty to companies. So I will ensure that this work is prioritised, that we do listen to stakeholders. Yes, of course, there will continue to be engagement, but we will support both large companies and SMEs, as well as other business partners who are impacted in the value chain. We should aim for a high level of harmonisation in respect of the transposition of this directive. And where there is foot dragging and where there are delays, we will not hesitate to act, because it is important that we proceed. And I will do all that I can to minimise the burden without detracting from the core objectives and the fundamental aims of this directive. The adoption of the Environmental Crime Directive in the last mandate was certainly a major step forward in ensuring that crimes against our environment do not go unpunished. And I want to assure you that I will work closely with Member States to ensure the swift and the proper implementation of the provisions in national laws in the coming months and years ahead.
For ECR, Mariusz Kaminski.
Thank you very much. Do you think that rule of law reports are so important, but I think they are not objective, not reliable, and very politicized? In the last few years, Poland has been attacked for allegedly violating the rule of law. In the report in 2023, one of the problems was arresting Spanish journalist. It wasn't a Spanish journalist, it was a Russian spy. Can you explain how such errors appeared in the report? And will you now see how is Poland doing on the rule of law right now? And will you take up the question of political prisoners? And there is no mention of that in the 2024 report.
Thank you very much for your question. As with all Member States, I will engage directly with the Polish authorities on the rule of law report, on the recommendations, ensuring that there is implementation initiatives in respect of those recommendations. I think that is important. The rule of law report under my stewardship will be evidence-based. It is an objective and reliable report. The Member State concerned will be given an opportunity to examine the country-specific chapter and to respond to the issues that arise within it. The Commission is the guardian of the treaties, and it is our job to ensure that the values in Article 2 are fully respected and upheld. And it will be a report that continues to be based on clearly set out methodology, where all voices are listened to from within the country, and of course the Commission ultimately will form its own assessment, and it is the Commission's responsibility to reach a conclusion in terms of the rule of law report. As you know, the Commission decided in May to formally withdraw the reasoned proposal and to close the Article 7.1 procedure for Poland. And as Commissioner, with your support, I will support Poland in the implementation of the measures it committed to take under its action plan on rule of law, as well as any other steps to protect and promote the rule of law in Poland. The Commission will continue to monitor closely the progress that is being made in that respect, and will report on this in particular under the rule of law process over the period ahead. We will use all the tools at our disposal to ensure compliance, but of course I will engage directly with the Polish authorities, and I will ensure there is an even-handed and fair approach adopted in all dealings with them.
For Renew, Jeanette Bayot.
A lot has been said already on the need to enhance our competitiveness and support EU business against unfair competition. It is clear that measures need to be taken in the coming period of time to create a level playing field inside the EU and outside the EU. You already mentioned the product safety regulations and the Digital Service Act, introducing new obligations for online platforms. My question would be, how will you ensure that digital platforms take their responsibility for safety for third country products sold to the EU consumer, and what additional measures will you support to prevent unsafe goods from reaching our market through these channels? And what would be the timeline that you envision for that?
Thank you very much, Madam Bayou, for your question. I think the context here is unprecedented growth in the level of e-commerce imports into the European Union. And if you look at the statistics, customs authorities in the EU are confronted with billions of small packages that are shipped directly to the consumer. 354 million of these items were imported in May 2024, which is twice the amount of May 2023, twice the amount in 1 year, and 3 times the amount of May 2022. This corresponds to over 10 million parcels per day. So this gives a real sense of the scale of the challenge that we face to ensure that consumers are protected and that product safety standards that we set in the EU, and we are a global leader when it comes to safety standards for products, are respected. As you know, last week, the Commission announced it has opened formal proceedings against Temu to assess whether the provider of the e-commerce platform has breached its obligations under the DSA in areas linked to the sale of illegal products and potentially addictive design of the service, the systems used to recommend purchases to users, and data access for researchers. So the scale and the gravity of this problem requires a coordinated EU response using all of the tools that we have at our disposal and an open-mindedness to developing new tools. The tool that is just about to come into being is the GPSR. And again, thank you all for your support for that. And that will now give the national market surveillance authorities takedown order powers. So if they see products that are unsafe on a platform being sold into the European Union, they can issue a takedown order to get that off the internet. And I think that is a proper power that they will have. There are other activities that will be done, online mystery shopping, organising product safety sweeps. So there's a huge amount of work that we will do, and we'll have to work very closely with the customs authorities, of course, as well, in terms of their obligations, and working then internationally with the jurisdictions from which these products are being exported to the European Union.
For the ESN, Eva Zajaczkowska-Hernik.
Pana CV. Dear candidate, I look at your CV and I see that your activity and everything you've done so far makes you actually one of the best candidates for this position. And I know that you have 7 children, so really congrats. And when looking at the opinion about the European Commission, especially in Poland, a lot of people thought hypocrisy, because Commission was quoting rule of law to justify numerous actions, such as, for instance, financial actions, sanctions imposed on Poland. Then we had a political change in Poland. No reform of the judiciary was actually put in place, but still the funds were suddenly liberated and paid out to Poland. No further doubts were quoted. Then we have potential new examples of other countries that might soon encounter problems just because maybe Ursula von der Leyen is not a huge fan of them. So how do you approach this? Do you agree with such politicized choices? Thank you.
Thank you for your question. The choices that will be made will be objective and will be based on the evidence that we have before us. And so where a view is taken, for example, following a reassessment in relation to Article 7.1, that a clear risk is no longer evident because of commitments that have been made, then that is the basis of a conclusion that the Commission would have reached. But of course, we have to see follow-through and we have to see implementation. And the point I'm making to all of the member states is that words are good, but actions are more important. And so we need to see the implementation and the follow-through of compliance with rule of law and the commitments that have been made. So I can assure you there will not be any hypocrisy in terms of the approach that I'm going to take. I will certainly be engaging on a bilateral basis with the Polish authorities, as I will be with the other member states as well over the period ahead.
And now the last speaker for the second round, for the left, Mario Furore.
Grazie, Presidente.
Thank you, Chair. Commissioner-designate, one of the pillars of our democracy is the independence of the media and journalistic independence, freedom of journalism. This is something that you've said previously. In the previous Commission, decisions were taken to defend rule of law. But we're seeing threats from other countries too. In Italy, there's a 2015 bill that gives the government the power to decide on the administrative manager of RAI, the public broadcaster, and to take decisions in relation to its board. So politicians are deciding upon the governance of the public broadcaster, RAI, and unfortunately we've seen the consequences. Italy is in position 46 in terms of global media freedom, and this critical point has been identified by international organizations. So the problem of the independence of the media facing interference from politicians is a problem in Europe generally, and as was the case with this 2015 bill under legislation in other member states.
Thank you very much, Honourable Member, for your question. And my approach with Italy will be the same as with all of the other countries. I will take the 2024 Rule of Law report. We will go through the recommendations. We will engage. We will see where there has been action and follow-through. And where there has not been, then we will hold everyone to account and ensure that the next steps are taken. I intend to follow closely the measures that need to be adopted in Italy to make sure that justice is more efficient and is quick. The establishment of a comprehensive regulation of conflict of interest, lobbying activity and financing of political parties to prevent corruption will be a priority for me. And as Commissioner, I will pay particular attention. You've raised the issue of media freedom, including the independence of the public service broadcaster, as well as the improvement of the safety and the working conditions of journalists, and to the protection of the right to demonstrate, as these are all essential for a free society. So the Rule of Law report provides us with the basis of making progress, and I think it should be acknowledged that overall, when I look at the data, I look at the recommendations across a whole range of countries and I see what actions it has led to. There has been significant follow-through. In the order of 2/3 of recommendations are in full or in part implemented. Of course, we want full implementation, but we also want it to happen swiftly.
Thank you so much. That concludes the second round of speakers. So I hand over to my dear colleague, the Jury Chair, for the third round of speakers.
Thank you so much. Then the first one is Sven Simon on behalf of AFCO, for the chairman. Simon, please. Same rule, 1 minute question, 2 minute answer.
Thank you. I have 3 questions. First, how would you engage to advance negotiations between Parliament and Council on Parliament's recent proposal for a European Electoral Act of May 2022? Second, how do you intend to address the Council's security concerns while maintaining Parliament's objective of maintaining control over European political parties and foundations? And the third question you already have answered. You mentioned the Commission's reports assessing the state of the rule of law in Member States, and it was addressed several times here. I would like to draw your attention really on the problem we face, that we have legal cultural differences. If you take, for example, the legal judge, gesetzlicher Richter, which doesn't exist in most member states, or the term is always used and translated with rule of law, but it has a different meaning, Rechtsstaatlichkeit or État de droit. So I'd really like to ask you to advance a unified understanding, an understanding that acknowledges
national nuances while reinforcing the rule of law as a cohesive rather than divisive force in Europe?
Mr. McGrath.
Thank you very much, Mr. Simon, for your question. And first of all, in relation to the European political parties and foundations, if I am confirmed, I will do all that I can to support the process of reaching an agreement on the proposal to amend the regulation on the statute and funding of European political parties and European political foundations. I think this is an important file. As indicated in the mission letter, I will work to rebuild a bridge between Parliament and Council, recognising precious expertise of the Parliament in the actual functioning of European political parties and foundations. We've come through some very, very difficult times over the last number of years with the invasion of Ukraine, and the focus has quite rightly been on an appropriate response to that. But I do believe that the legal framework of the political parties in the European Union and foundations, it does need to be developed to reach their potential under the treaties, and I want to work with you in relation to all of that. In relation to EU electoral law, again, I look forward to working with your committee in respect of the competence we have at an EU level, and of course recognising the principal role that there is at member state level as well. My bottom line will be, I want to see more democracy. I want to see more participation in elections, and if there are changes that we can make at an EU level, or encouragement that we can give to member states using the tools at our disposal to empower more of our citizens to participate more actively in the democratic processes of the European Union, then that is something that I will do. And I'll pay particular attention to the issue of mobile EU citizens, because too many of our EU citizens are not given an opportunity to participate in the democratic process.
Next is Chair of Code Committee, Neo Ryu, please.
Dear Mr. McGrath, on behalf of the CULT Committee, my question is the following. Given the division of responsibilities for media policy, how do you plan to ensure coherence and regulatory consistency between the European Media Freedom Act, the EMFA that you've mentioned before, and related legislation such as the Audiovisual Media Services Directive, the AVMSD, especially considering that they fall under different Directorates General, DG Just for EMFA and DG Connect for AVMSD. How will you avoid the fragmentation of oversight and potential discrepancies in the EU media policy if these key frameworks are not managed under the same Directorate General? Thank you very much.
Mr. McGrath.
Thank you, Madam Reel, for your question. And the first thing to reassure you is there will be very close cooperation between myself and EVP-designate for Cunnin. We have already discussed this issue. I have met with DG Connect. My own DG will now be taking responsibility for the implementation of the European Media Freedom Act, and we will ensure that there are proper procedures in place so that the coordination is really close, because it needs to be. Because you are correct, EMFA is an integral part of EU media policy. It builds on the long-standing framework that we have on the Audiovisual Media Services Directive, and I think when you take them together, they give us a very good opportunity now for a comprehensive set of rules that foster the internal media market, allow media companies to operate freely across borders, but also for our consumers to have access to diverse media content. EMFA does take account of the unique place of the media in our democracies and in our culture, and my focus now will be on the swift implementation of EMFA, and in that regard the setting up of the new board for media services, which is an upgrade as such of ERGA, which is the current network of national regulators under the AVMSD, and this will make the cooperation among regulators much more efficient, and I will ensure that the two instruments are applied in a cohesive and a coherent manner, and will work very closely with EVP Verkunnen in that respect. So getting that board and its secretariat up and running will be a key priority. We will also ensure that EMFA rules on findability of media content, on connected television and audience measurement are swiftly implemented also, and to ensure that a regulatory fitness check on all member states is carried out to ensure that the implementation is well on track for the August 2025 deadline. I look forward to working with your committee over the period ahead on that.
Thank you. Next is Monica Holmeyer, first Vice Chair of Budget Committee.
Thank you very much, Chair. On the one hand, dear Commissioner-designate, we were glad to read in your written replies that you are ready to ensure the best possible direct information flow with the Parliament. On the other hand, you underlined the duty of sincere cooperation with the Member States concerning the monitoring of the fulfilment of the horizontal enabling conditions. How will you reconcile these two commitments and ensure that the Parliament, as one arm of the budgetary authority, is informed in a timely and transparent manner about the ongoing discussions with Member States, the assessment of the Commission, and, when applicable, the breakdown of frozen funds by tools aimed at protecting the financial interests of the Union against breaches of Union law?
Dear colleagues, can you have your bilateral conversations outside of the room? Because it's really difficult for the Commissioner-designate to be concentrated after so many hours. Mr. McGrath.
Thank you very much, Madam Allmeyer, for this question. And I think it's important to reaffirm my commitment to provide complete, timely and detailed information to Parliament, and together with the Commissioner for the Budget, who of course is responsible for the conditionality regulation, and indeed other commissioners responsible for the horizontal enabling condition on the effective application and implementation of the Charter, we will strive to provide Parliament with the breakdown of frozen funds by tools aimed at protecting the financial interests of the Union against breaches of Union law. So there needs to be information flow consistently and happening in a seamless manner. And I give you that commitment. I anticipate I'll be coming before the relevant committees of the Parliament on an ongoing basis in that respect. I think the horizontally enabling condition is an effective tool that helps us to enforce the implementation of the Charter of Fundamental Rights. And of course, in the context of the next MFF and the next Common Provisions Regulation, there will be a need to examine what is an appropriate legal basis for the next mandate in terms of ensuring that the Charter of Fundamental Rights is fully upheld over the period ahead. Of course, the Commission is mindful of its duty of sincere cooperation with the Member States, given that the monitoring of the fulfilment of the horizontal enabling condition is based on a constant dialogue and engagement between the Commission and the Member States. And of course there will always be political sensitivities around discussions where EU funding is involved, and that's why it is important that there are clearly established lines of communication and information flows set up involving the relevant commissioners, the relevant parliamentary committees, and I give you that solemn commitment to work in a genuine spirit of collaboration with you and your committee members over the period ahead.
Caterina Canici, first Vice Chair of Cont Committee, please.
Grazie. Grazie, Presidente.
Thank you. Thank you, Chairman, and thank you, Mr. McGrath. Well, I'd like to follow up on your written responses to the Parliament and ask whether you could provide further information on clear measures that you intend to adopt to guarantee that the recommendations on the rule of law report that have an impact on the EU's budget be followed up on in a rigorous manner. How will these actions be consistent with the general goal to boost the anti-corruption architecture and our anti-fraud architecture? And could you tell us about the agreements that you will implement to cooperate with public administration and the Commissioner in charge of fighting fraud? Thank you.
Thank you very much for your question, and I think it's important that we acknowledge the role of the rule of law report. It is a preventive instrument. It is designed to effect positive change within member states in terms of compliance with rule of law, but it is just one tool. We also have tools that we can respond where breaches take place, and we will not shirk in our responsibility to do that. I also think it's important that we support the member states in their efforts to tackle corruption. As you know, there are proposals for a new anti-corruption directive as part of an anti-corruption package. I think that should be a priority for this Parliament, and certainly will be for myself, and I look forward, hopefully, to working with you in that regard. I also will do all that I can to support the organisations that get funding under the SERVE programme and the Justice programme, because I think they do excellent work and they can really help us in that regard as well. So when it comes to anti-corruption, when it comes to anti-fraud, I will have to work hand in glove with the Commissioner for the budget, and of course with the Parliament as well. And the centrepiece of what we need to do here is to give effect to the ask, which is that respect for our values and respect for EU law is a requirement for access to EU funds. So that will require a considerable evaluation and thinking as to how best we do that we build on the existing architecture, but that we strengthen our grip on rule of law to make sure that there is that direct link that the President has now given us a mandate in which the Parliament, through its vote, has supported.
Lina Galvez, Chairwoman of FAM Committee.
Chair, Mr. McGrath, as Chair of the FAM Committee, I will make you 3 questions. The first, how will you ensure that equality continues to be prioritized as part of the democracy, rule of law and fundamental rights portfolio in the current Commission, and what will you do to ensure a link with the Commissioner for Equality? The second one is, how do you plan to safeguard women's rights against gender misinformation and related anti-democratic movements and protect women's rights defenders and civil society activists? And finally, the third one is, given that the measures of combating violence against women and domestic violence are not yet implemented in all member states, and given that the regional disparities concerning this matter are notorious when analyzing national legislation and statistics, what are your concrete plans to decrease these regional disparities and ultimately ensure more prevention and protection of victims? How will you take into consideration the under-reporting of these crimes? Thank you.
Mr. McGrath.
Thank you very much for your question on behalf of the committee. And first of all, can I give you an assurance that I and this Commission will not handle the equality portfolio any differently from the previous Commission. My predecessor, Commissioner Reinders, was in charge of justice. Commissioner Dalli was in charge of the equality, and in the new Commission it will work in the same way. If I am confirmed as Commissioner, I will ensure that there is a horizontal application of the equality perspective, that is not just a pot we dip into every now and then, but it applies uniformly across the board in everything that we do. For example, promoting inclusiveness in our democracy. In the upcoming Democracy Shield, there will of course be an equality dimension to that. There certainly is when it comes to the safety of candidates that I alluded to earlier on, and of course we have the new Victims' Rights Directive that I am really anxious to try and bring forward. In relation to your question about gendered misinformation and anti-democratic movements, together with the Commissioner for Equality, we will consider how best we can tackle this phenomenon in the upcoming revision of our LGBTIQ and gender equality strategies. I can already highlight some elements, but time is limited. I want to ensure that the EU budget continues to support civil society in the areas of fundamental rights, and especially in matters of gender equality and LGBTIQ rights in the EU and beyond. Your third question was in relation to combating violence, I think, and I just want to assure you I'll be working closely with the Commissioner for Equality to ensure proper coordination of the implementation of the legislation that has been passed, the Directive on Combating Violence Against Women, within the general framework of victims' rights. I think that is important. 22 Member States now are bound by the requirements of the Council of Europe Convention on Preventing and Combating Violence Against Women and Domestic Violence, and hopefully more will do so.
Thank you. The last round is reserved for political groups in order. So the first one is Alexander Sell on behalf of ESN.
Thank you, Mr. McGrath, for coming here today and answering our questions. I'm sitting here as a representative of a party which is supported and has been elected by 6 million Germans. We are one of the biggest parties in the country. We have actually more electors behind us than there are people in Ireland. There are other similar national conservative parties across Europe. There have been very many electing parties in France. 1.4 million Poles have elected Confederacja party. So despite this, the members of this parliament from our party have been excluded from posts in this parliament and have actually been bans imposed. And no other party is so often the victim of political violence as we are. This is the state of democracy in Europe. Democratic right of speaking out is not only curtailed in Russia and China, but also here. Mr. McGrath, you want to be Commissioner for Democracy and rule of law, and I'd like to ask you, therefore, how do you think, what's your position on the curtailing of participation in the so-called cordon sanitaire here in the Parliament, and what do you think about the German government's opposition to the elected party? And also, I'd like to know...
Thank you, Honourable Member, and I am a Democrat to my core. I respect the democratic mandate of every individual who is elected by the citizens in a member state or in a European election context. So I respect mandates for sure, and I'm happy to engage with anyone who subscribes to democratic principles. However, where there can be no compromise is in respect of our values in Article 2, democracy, equality, rule of law, freedom, respect for human rights, human dignity. There is no room for compromise. These are not optional extras. They are not a la carte. You cannot pick and choose. So respect for them, respect for the Charter of Fundamental Rights, and respect for our democracy in every form is absolutely essential to the work that we do. So those are the guardrails. Those are the parameters within which I will engage with everybody and listen to their perspective. But there will be no compromise on the essence of what constitutes our European Union. And what I have referred to, this is EU law. The values in Article 2 are EU law. The Charter of Fundamental Rights have full treaty status since the Treaty of Lisbon. And all told, the Charter is almost 25 years old, and it should be celebrated next year in that respect. No compromise on those issues, because the future of our European Union and the future of our democracy is at stake.
So, for the left group, Bernardo Barena, please.
Thanks, Chair. Commissioner-designate McGrath, considering the Schrems I and Schrems II rulings, which both underscore the importance of protecting EU individuals' data from mass surveillance and led to a reassessment of the US adequacy status, how can the European Union justify granting adequacy status to Israel, where similar concerns about mass surveillance and privacy violations have existed for years? Would you acknowledge that by depicting Israel as a model jurisdiction for data protection and a geopolitical ally, without properly addressing its well-documented disregard for privacy and data protection rights, the EU is effectively normalizing mass surveillance practices, and that now these practices are nowadays enabling atrocities in Gaza? As a result, the Union could be identified as complicit in activities that implicitly recognize or sustain Israel's unlawful occupation. Can we have your assessment on this issue, please? Thank you.
Mr. McGrath.
Thank you for your question. When it comes to adequacy decisions, the European Union has to be satisfied that the same level of safeguard is in place in the partner country as it is within the European Union. So that is the fundamental question that has to be answered when an adequacy decision is being reached. Do we have the confidence? Can we be sure that the same safeguards that we have in the European Union in relation to data protection is fully respected by our counterpart? And it is in that circumstance that the European Commission will make a decision in respect of an adequacy decision. And of course, we'll continue then to monitor on an ongoing basis the implementation of all of the adequacy decisions that are currently in place. And it is the objective of the Commission, with a view to facilitating trade, to facilitating mutual cooperation, that within those parameters and within those safeguards of respecting in a mutual way the level of data protection safeguards, it is our objective to enter into further adequacy decision arrangements over the period ahead.
Thank you. For the Greens IFA group, Jaume Asens Yodra, please.
Thank you. Commissioner-designate, 3 questions. You talked about disinformation. We agree that without truth there is no freedom, and that lies erode the right to receive accurate information. We saw that with the storms in Valencia. There was confusion, disinformation, fear, hate, and even attacks on the Prime Minister as a result of disinformation spread by the right. If these instruments can be tackled in some way through legislation, what form would that take in your view? And in the case of Hungary, organised civil society, can you commit to introducing a chapter on the civil society in the rule of law report? Finally, how will you work with European cross-border areas in negotiations which are forthcoming with Council?
Thank you for your question. In relation to the rule of law report, we will keep its composition under review. I have a commitment that I must deliver on, which is to include a single market dimension. So that will be the first priority. Of course, civil society organisations are part of the rule of law report process and do feed into the consideration by the Commission of the different issues that are being assessed every year in the context of each country-specific chapter. I think when it comes to disinformation, we have a lot of work to do. We have put in place very significant architecture over the last number of years, and I want to acknowledge all of the work that has been done, not least with the Digital Services Act. But there are also further steps that I think we can do. There are other tools and cooperation structures that we can continue to roll out. Rapid alert system. We can work with the European Cooperation Network on elections, the European Digital Media Observatory, the Code of Practice on Disinformation, which is becoming a Code of Conduct on Disinformation under the Digital Services Act. And of course, we are committing in the political guidelines to the establishment of a European network of fact-checkers. And I think that is important, that we empower our citizens to get to the truth and to get to the heart of the matter and to make up their own mind based on the facts. Nobody should fear the facts. And that is what I think we should seek to do as part of the work on disinformation over the period ahead.
Thank you. For the New Europe Group, Moritz Kjörner.
Dear Commissioner-designate, the decline in the rule of law in certain member states has had a negative effect on the fair treatment of companies and the SMEs in the countries. In order to incorporate competition law enforcement into the EU rule of law monitoring framework, Can you today promise that within the first 100 days, after being confirmed, you will establish a joint team from DG Comp and DG Just and to task them to ensure that competition law are upheld within rule of law standards and vice versa? And also you mentioned the progress on the rule of law toolbox as a whole. Thanks to the pressure, I think, of the Parliament, but also of your Commissioner Reinders. But the best toolbox has to be used. So are you really willing to be strong there? And even if it creates tensions, or to put it blindly, will you be a pain in the ass of wannabe autocrats in some member states? That's my question.
Mr. McGrath.
Thank you very much for your question. Well, first of all, on the treatment of SMEs in the context of rule of law and what we can do within the annual report, I acknowledge that respect for rule of law is a key ingredient in any successful economy, and for a business environment that fosters innovation and investment, it is a prerequisite, and companies need to have that confidence. So at an early date, and I've committed to the next iteration of the annual rule of law report, we will provide for that single market dimension, dealing with the issues around legal certainty, equality before the law, and the prohibition of arbitrariness, also in a single market, with a view to enhancing our competitiveness and also the protection of investments. In relation to the rule of law more generally, my approach will be, yes, dialogue, I will be diplomatic, but nobody should misstate that for weakness, because there is a cast iron commitment to acting with the tools that we have now, and then working with all of you on the strengthening of the tools, particularly around the connection with the EU budget over the period ahead. And that is the fundamental commitment that I can give to all of the members of the European Parliament over the period ahead. There will be tensions, of course. There will be difference of opinion with member states. We have to make more progress. The architecture is there, but yet in parallel we are seeing a deterioration in too many instances. We have to reverse that trend, because it will otherwise come at an enormous cost to all of us. So I am prepared to do whatever I need to do within the framework of tools available and those that we might yet negotiate to enforce that.
For the ECR group, Kosma Złotowski.
Dziękuję bardzo, panie komisarzu.
Thank you, Commissioner. My question is, the issues of single market in the EU, to what extent are you going to reflect that in the status report on the rule of law? Would you take account of administrative and digital barriers? And then about AI. Obviously, development speeds up enormously, a lot of opportunities, but a lot of threats as well. So how do you see AI as a tool to support rule of law and the judiciary? Would you envisage special law or legislation in this regard? And once we have the AI Act in place, would you see a necessity to continue work on the directive on responsibility of the AI?
Mr. McGrath.
Thank you very much for your question. Well, first of all, in relation to AI, it will play an important role in the digitalisation of justice agenda. And I do see a lot of opportunity using AI, for example, in areas like mass claims to improve the efficiency of the process and the system. And so in terms of bringing forward that digitalisation of justice strategy, AI will be an important part of it. And I look forward to hearing your views on that in relation to that development. On the rule of law report itself and the single market, you've raised a number of issues that you feel it could consider, including administrative and digital barriers. I think fundamentally what it is seeking to do is to examine whether there is a level playing field. across the European Union on rule of law issues for businesses that interact with other member states. And I think it's a common sense test in many ways, that if a business trades on a cross-border basis, can they have confidence that contracts entered into will be enforced? Can they have confidence that the judiciary, if a matter comes before them, will act independently and not by default in favour of the home member state party, for example? So those are the kind of issues that are important. They need to know that there will be recourse, that there are checks and balances, that there are appeals mechanisms, that there's an ombudsman. You know, you need to ensure you have these institutional checks and balances in place that are essential for the smooth operation of a single market on a cross-border basis, and that will be the perspective that I will bring, but of course we will develop it for the next rule of law report.
For the PAF group, Ton Diepeven, please.
Mr. McGrath, I do my question in Dutch. Mr. McGrath, eerder deze morgen heeft u geantwoord dat de bedreiging van onze democratie niet alleen...
Mr. McGrath, you said that the threats to our democracy don't only come from abroad, there are also internal threats. And so I would ask you, what would you say about the firewall that's in place and remains also in the European Parliament? This firewall, well, don't you think that it's a violation of democracy because it excludes so many citizens who voted for certain parties? Thank you.
It is a matter for the Parliament to decide how it conducts its business, how it makes arrangements for committees, for the allocation of positions and so on. This is a democratic chamber, and I respect the mandate, as I said, of everybody who is elected to this Parliament, but it's not for me to pass comment or judge or interfere with the internal workings of the European Parliament. My job is to make sure that the Parliament is respected as an equal with the Council, that we ensure that as a Commission we engage fully and meaningfully with you. And that is my commitment, to appear before you on a regular basis in whatever format you deem appropriate, whether it be structured dialogue, whether it be the formation of a contact group. I think there are lots of areas where we are going to be working together, and I will work with people from across the political spectrum. But the caveat is, once again, that there will not be any compromise on our democracy, on our values, and on our fundamental rights.
For S&D Group, Ana Catarina Mendes, please.
Sr. McGrath.
Mr. McGrath, today is an important day for democracy around the world, and it will be your task to continue to defend democracy in Europe. You will have responsibility for applying the Charter of Fundamental Rights. In that respect, I'd like to raise 3 points. What measures can be taken in relation to member states who violate Article 21 specifically of the Charter of Fundamental Rights by not recognising unions of same-sex couples or birth of their children? Secondly, Mr. McGrath, this Parliament approved the inclusion in the Charter of Fundamental Rights of the right to legal, safe abortion. What steps will you take to ensure that that is respected? Thirdly, Mr. McGrath, over the next 5 years, will we finally ensure that the European Union joins the European Convention of Human Rights?
Thank you very much for your questions. In relation to what we can do as a Commission to enforce the Charter of Fundamental Rights, then of course we can take infringement proceedings, and we stand ready to take infringement proceedings. The Commission has already done that in a number of different instances in relation to the Charter, and that is an approach that I support. The Charter of Fundamental Rights is EU law, and so it is not discretionary. It is not an optional extra, and I think that is the important point. In relation to the children of same-sex couples, I know there is a file on parenthood, which should not be viewed, in my opinion, as a threat to the rights of member states to legislate in certain areas, but it does mean that a child should not suffer where families move cross-border. If there is a parent-to-child relationship in one member state and they move to another member state, then the same relationship exists. And I think if we all adopt a child-centred approach and think about the interests of the child, then we should be able to make progress on files such as that. In relation to including the right to an abortion in the Charter of Fundamental Rights, I am aware that this is an issue the Parliament previously took a position on. It's not a political commitment in the guidelines or the mission letter, so I can't make a commitment on behalf of the whole College of Commissioners. But what I can say is I and the Commission will work constructively with the Parliament should you wish to proceed formally with that measure, though of course recognising it is treaty change, and again it is on the basis of unanimity. And yes, I do believe that this will be the mandate where we finally sign up to the ECHR, and I want to work with you to remove any remaining obstacles and make sure that that happens as quickly as possible.
Okay, last try. Axel Voss for EPP. All eyes on you, Axel.
And so last question, hopefully not the most weird one for you. So it's about third-party litigation funding. The Commission's agenda includes efficiency and fairness of civil liability redress systems. This includes to ensure that litigation systems and consumers can be safeguarded against exploitation by profit-seeking intermediaries. Your predecessor considered to regulate such a third-party litigation funding, which followed a resolution supported by more than 80% of the European Parliament. So how will you ensure that systems of civil redress are appropriately safeguarded so that public redress systems serve in the interest of the consumers and society rather than profit-seeking intermediaries? And will you support a regulation on the third-party litigation funding industry, including the safeguards identified in the Parliament's resolution?
Thank you very much, Mr. Voss, for raising this important issue. Third-party litigation funding, which, as we know, is the coverage of litigation costs by external financiers in exchange for a certain percentage of the proceeds in case of success. It's a relatively new, but it is a growing phenomenon worldwide and also here in the European Union. And while, on the one hand, it does offer the potential to enhance access to justice, which is a good thing, where legitimate cases could not otherwise be brought without the funding, but it could also lead to possible risks such as conflicts of interest. So I think we need to be clear-eyed about the issue of third-party litigation funding. The EU already addressed the issue in the Consumer Collective Redress context with the Representative Actions Directive, including mandatory principles to prevent conflicts of interest and undue influence of funders on parties that must be followed by Member States if they follow third-party litigation funding. The Parliament's resolution on the responsible private funding of litigation, I know, was adopted last year, proposed very detailed horizontal regulation not limited to the consumer area. It indicated a proposal should only be tabled after the expiration of the deadline to transpose the Representative Actions Directive, and also taking account the effects of that directive. So, in line with the commitments made by the Commission to the Parliament regarding follow-up, the Commission has launched a mapping study to collect information on the current state of litigation funding in Member States, and I anticipate that this study will be concluded before the end of the year, and I do commit to examining the outcome of that study then to see whether new legislation might be required, and will work to prioritise full and effective implementation of the Representative Actions Directive by Member States with a clear focus on litigation costs and funding. So we need to strike an appropriate balance, and I'd like to tease that out in more detail with you and your colleagues as to where that appropriate balance is.
Mr. McGrath, thank you for answering all the questions, and now I give you the floor for the concluding remarks, up to 5 minutes, please.
Thank you very much, Chair and honourable members of the Parliament. Can I just thank you for your questions today, and I've done my best to answer the questions, but more than that, I hope that you get a sense of who I am and my approach, which will be collegiate with all of you. The relationship that I hope we can build will be on the basis of mutual respect, and where we agree, we'll proceed as quickly as possible. Where we don't, we'll have dialogue, we'll try and iron things out, and we'll find a way forward in the interests of the citizens of the European Union. We've discussed a very wide range of topics here today on rule of law, protecting democracy, media freedom, protection of consumers, how we protect children online, how we reduce the burden of red tape for businesses in the European Union. And my duty, should I receive your support, will be to work hand in hand with the European Parliament and with all Member States, because I also believe that this is how we advance together in the areas of our common interest across democracy, justice and the rule of law. And we have discussed in detail today there will be a lot of work to do to emerge stronger as a union at the end of this mandate in 5 years' time. Democracy must work for everyone and not in name only. And we have to ensure that our citizens have a sense of belonging to our society, but also to our democracy. And they have to be assured about the values that we have, that they will be respected, that we protect individual rights, and that we support them when they need help. We share a responsibility to defend the foundations on which our economies and our societies are built, the rule of law. And there can be no ambiguity in this, as I've said today on many occasions. And the fight against crime must be made more effective across the prosecution chain, and where we can have greater cooperation between different bodies and between Member States in the fight against crime, then we owe it to our citizens to achieve this. A stronger union is also dependent on Europe advancing the prosperity of our citizens, the opportunities we provide for businesses. An important factor in all of this will be on how 450 million European consumers are being treated. And that's why digital fairness and enforcement are clear priorities here. And effective civil justice systems can support a thriving investment and business climate, as well as help innovative companies to grow. As I noted at the very beginning, you represent no fewer than 8 parliamentary committees. This reflects the very diverse nature and wide breadth of the portfolio, and if I am confirmed, I look forward to regular attendance at your parliamentary committees relevant to my mandate for structured dialogues and discussion on implementation, on enforcement, on new ideas and on potential new initiatives. My door will always be open to members. I will work with you in a genuine spirit of collaboration over the next number of years, should you be in a position to support me. Thank you all very, very much.
Thank you, Mr. McGrath, for all your interventions. They have been closely scrutinized. I mean, we haven't finished the session yet, please. Just hold on a second. I also thank my colleagues for their questions and the readiness to keep the session roughly in time. And let me once again remind that this process is a vital step in setting up the new European Commission, which will shape the EU policies and actions for the next 5 years. So,
yeah, thank you. It's fine.
okay, I declare this meeting closed.